তোমার এই করা নেই?
হ্যাঁ আচ্ছা আচ্ছা
আচ্ছা এটা হয়নি দেখছি। হ্যাঁ ওয়াইফাই তো করা আছে না, কিন্তু দেখাচ্ছে যে মিউট এটা চলবে অডিও। তোমার দেখো তো অডিওটা করা আছে কিনা, জোরে করা আছে, এ করো অডিও করা আছে, এখানে করা আছে অডিও। তুমি এটাতে দেখো তো ভলিউম ঠিক আছে কিনা, ওই দেখো ভলিউম করা নেই।
মিউট করা আছে,
করো 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 এটা করো।
আনমিউট এটা right now sound is there.
তুমি এদিকে দেখবে হেডফোন
হেডফোন আছে
ভিডিও আমাকে এখানে দেখছি। এই তোমাদের কাছে হেডফোন আছে? আমাদের হেডফোন আছে না?
এ তো ইয়ে হচ্ছে না তো,
পেনগুলো আমার নিচে আছে বলে মুশকিল না। তুমি এখানে দেখো না, দেখতে দেখতে আমার হাতে করেই দেখো না।
সাউন্ড তো পাচ্ছি না। খোলা আছে বলে হচ্ছে না।
মাইক্রোফোন আনমিউট করো ঠিক আছে। ওটাও হলো না, ডান্স।
গাড়ি হয়েছিল।
আস্তে আস্তে দাঁড়াও। হ্যাঁ
তোমাকে তুমি ইচ্ছে করো।
হ্যাঁ হ্যাঁ, না না।
ওইটাতে
না, ওখানে
না, আওয়াজ হচ্ছে না তো। মিউট, স্টপ ভিডিও, হাউলিও, মিউট চাই, share, captions, whiteboard chats, participants, participants দিতে হবে।
পেছন থেকে এসেছে। ঠিক আছে, আউটকামটা করে নাও।
এখানটায় কিছু করতে হবে। লাইভটা করি?
না, লাইভ তো হচ্ছে না। লাইভ তো হচ্ছে না। খালি দুজন পার্টিসিপেন্টস।
আর ওরা ওদিকে আছে।
না, তাহলে বেশি থাকতো। ওদিকে আছে আবার পার্টিসিপেন্টস, একটা মিটিং এর সবাই থাকবে, তার মানে এখনো পার্টিসিপেট করেনি।
ওরা সাইলেন্ট করে রেখেছে, ওরাই হয়তো সাইলেন্ট করে।
সাইলেন্ট করলেও পার্টিসিপেন্টস দেখাবে।
শেয়ার বলে কিছু আছে? শেয়ার কার সাথে শেয়ার? only the host can share this video. আচ্ছা,
আর কিছু করো না, যা হচ্ছে
reactions, stop video করে নাও।
হ্যাঁ মিউট, ঠিক আছে।
এটা এখন মিউট হয়ে
মিউট হয়ে মানে তোমার দিক থেকে মিউট হয়ে গেল, কিন্তু শোনা যাবে।
কিন্তু ওই আওয়াজটা এলো, ওই তোমার ফোনের আওয়াজটা এলো, মানে ফোনে যে মেসেজ আসে।
লাগানো আছে।
না না
আগে না তুমি ছিলে না তখন আমি এগুলা এই যে স্পিকারটা ক্রস নিয়েছে ওরাই আর কি মিউট করবে
না না
হোস্ট হ্যাজ
এটা কেন হচ্ছে বলবো
host has host has blocked the sound. So I will put my attention. এর জন্য এতক্ষণ ধরে কথাটা হচ্ছে এখানে আর কিছু রিপোর্ট করতে পারি না আমরা কিছু ইলেকশন শেয়ার ইলেকশন চ্যাট
আমার স্টপ ভিডিও করে দাও স্টপ ভিডিও করে
সব ভিডিও করে
ব্যাক করো
এটা দেখ এটা গেল
না যেটা ফোন হবে না যেটা তুই ফোন করো না
না না এই তো এখন কিছু কথা বলতে পারি ঠিক আছে চ্যাটটাই করে দিয়েছি
প্রচুর না বেশি এটা করাই তো আছে অনই আছে
লাইভের জায়গায়
ওটা হচ্ছে মাইক্রোফোন
চ্যাটটা করি
না
এখানে মানে
চ্যাট করবে
হ্যাঁ মানে বলতে
I can't hear.
I can no sound.
I can't hear.
अच्छा अच्छी भी चीज है
তুমি তোমার এটা বলো
আচ্ছা
আস্তে আস্তে না কেন তোমার এটা বলো না সাইটটা বলো না তোমার মেলটা বলতে হবে মেল খুলতে হবে
মেলেই আছে मेल बॉक्स करो ना अभी मीटिंग ना ना आई मेल बॉक्स ना खुले पासपोर्ट
না পাসপোর্ট তাহলে তো জুম মিটিং এ মেল খুললে সুবিধা সব দিতে হবে তোমার না না এটা তো মেল করে ডাইরেক্ট চলে যাবে
আমি আমার পাসওয়ার্ড দিতে হবে চলে গেছে না এখনো চলছে না পাশে একটু লেখো না ফার্স্ট 1 ST করো 1 SC JUL 35 তাই
না কিন্তু এমনি মেসেজ আসবে
এই যে আমি মেসেজ দিলাম
না না ওটা না, এমনি একটা message আসবে। যেটা তোমার ভেরিফাই না
আমার
শুনতে পাবেন এটা হচ্ছে না। এটা যেহেতু অন্য জায়গা থেকে আচ্ছা আগে এটা দেখো তুমি একটা ভেরিফিকেশন কোড পাবে না ওটা হয়ে যাবে মেসেজ কোথায় তোমার ফোন নম্বর বলো তাড়াতাড়ি
98300 59286
98059
286
এবার আসলো মেসেজ আসলো
হ্যাঁ
336430
হ্যাঁ 336430 336430
আচ্ছা
হয়েছে তো এখানে বিনা দাসের
No, 37, my lord. There's a 21/11/2022 is the final order.
That is at page 34.
34 also
37, my
30.
lord, last order 37.
No, it's a continuation. 34. There is also a mention of order 21/2022 and 37. Yes, my lord can take 37.
It's the same order.
Same.
Yes. But how is it recorded that the petitioners were present, they were heard?
No, this is wrong.
Notice duly served.
This is wrong recording. Well, it was never done.
This is the format, that is why.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
The report is fine.
Paragraph. The petitioner has assailed the order passed by the block. This is by the BLLR.
Is a BLR
By
of
the Block Land and Land Reforms Officer under section 50 of the West Bengal Land Reforms Act 1955 on 21st November 2022, primarily on the ground that the petitioner was not granted an opportunity of hearing before the order was passed. Stop. The petitioner pleads violation of natural justice. Paragraph. It appears from the report in the form of affidavit submitted on behalf of the state respondents that notice was issued in the name of a wrong person and no notice of the hearing was issued upon the petitioner at all. Strangely, paragraph. The order impugn records that notice was duly served and the petitioner was present before the authority at the time of hearing. Stop. Paragraph. Since it is evident from the record that no notice of hearing was served upon the petitioner and the order impugned was passed without providing an opportunity of hearing to the petitioner, the order needs to be set aside. Paragraph. The order dated 21st November 2022 passed by the Block Land and Land Reforms Officer in case number MN/2022/1608/28399 of 2022 is set aside / quashed. Paragraph. The Block Land and Land Reforms Officer, being the fourth respondent hearing, is directed to revisit the issue upon service of notice upon all the interested persons, including the petitioner and the private respondent, and affording an opportunity of hearing to them and pass a reasoned order within 1 month.
Yes, sir.
Yes,
Yes.
within 1 month from the date of communication of this order, in accordance with law. Paragraph. The decision taken by the authority, not necessary, it's an appealable order. Disposed of.
Lordship,
Hearing on behalf of the petitioner, led by
Lordship.
Mohammed Sabir Ahmed, on behalf of the
Lordship.
petitioner.
I am for the Rajpashanapur municipality, Lordship. Lordship, I required Lordship 3 weeks time for filing affidavit, Lordship. The concerned engineer went to the spot, Lordship. but it appears that there is no private respondent was present, Lordship, without the knowing the papers and documents from the private respondent, it is not possible to file a affidavit, Lordship, and let the BLRO report will say everything, Lordship.
There is a direction for affidavits. Affidavits are not ready, I think.
No, ready, it is required time and to verify the documents of the private respondent.
You are
Lordship.
appearing for the state?
No, I am for the Rajput Municipal, state is here.
Who is appearing for the state?
BLRO report.
You are appearing for the state?
Last occasion, my lord, directed to the BLRO to file a report.
Copy maybe.
একটা কপি আমাকে দিন। Thank you.
This was an interim report called for. The matter needs to be heard on affidavits as recorded in the earlier order. So please come back on affidavits.
Lordship, private respondent have not appeared till date, Lordship. That is there should be direction
Where
in
is the
spite of.
service private respondent?
I have served, that is.
অনেক দিন আছে। Lordship, kindly see, the municipal engineer also went to the spot, but they are not available. The shops, rooms are closed.
Kindly, my lord.
Private respondents are all served.
My lord, I have served, but the service will be returned, my lord, due to their address problem, my lord. Now kindly see the report submitted by the BLRO, page 2.
Lordship, service of the private respondent is very much required, Lordship.
Come back.
They will be affected, Lordship. How the steps will be taken?
My lord, they have also issued notice to the private respondent for
No.
my lord, conducting the hearing. That was not done. That was in that hearing petitioner were present, but my lord,
Lordship,
not done. My lord, kindly see the report filed by the state respondent.
I
Page
don't know, they have
4,
mentioned that
my
name of.
Page 2, paragraph 4, my.
Yes.
It has also been found that there are some construction beside sewage line covering such and such allegedly erected by the respondent number such and such, which are obstructing the ingress and egress of the petitioner through Metal Road, my lord. So my allegations have been, my lord, substantiated and supported by the my lord state respondent by filing the affidavit, my lord. Though it has been served today, my.
I understand that is there, but then you have to serve the private respondent.
Adjourn
Please
for a
show me
short date,
service.
my lord. Kindly adjourn for a short date, my lord. Then I'll
Serve the
serve
private
again
respondents and come back.
and come
Yes.
back. my lord.
Otherwise, this becomes a ground for appeal. It will not help you. It will only
Lots.
delay the matter, isn't it?
My lord.
Lordship.
And in the meantime, my lord, the report
Both are-
filed by
তুমি নাকি
the
affidavit file
hearing
করতে
conducted
বলছো?
by the concerned municipality,
বলো না, আমি file
my lord, that is to be carried out, my lord, in the meantime. They will also, my lord, serve the notice to the private respondent for my lord, present at the time of, my lord, causing the inquiry.
No such direction, ABDB in opposition filed by the state. Only last occasion, my lord.
It is recorded that the parties have already been served. It is recorded. So no need of further service.
Lordship, so Lordship, kindly, Lordship, this is the coordinate bench, Lordship. Lordship has every right, Lordship. Lordship, whether the private respondent has been served or not, after going through the inspection report, Lordship, that is why there is no private respondent, Lordship. This ultimate effect will be upon the private respondent without any notice, without any.
Taking the brief of the private respondent, sir?
No, ultimately the construction should be demolished of the private respondent, and as per rules, they have been should be given an opportunity. That is the my content.
Please, if they are not found, they are not heard, it is their responsibility, not yours.
I was under the impression that you are appearing for the private respondent.
No, Lordship,
From
this
your
is a,
submission.
this is a report of the municipality.
So please do not make your submissions in favor of the private respondents.
No, I'm
Like
apprising the
that-
code, the actual situation. I am apprising the code, Lordship.
It
That
is
is the issue.
Private respondents are.
Private, my lord, private
Encroachment by the private respondents is appearing from the report of the state,
Ebong-
BLRO.
authority has served the
And the
notice.
court has said it is either a report in the form of affidavit or opposition. I don't think an opposition is required in this matter. A report in the form of affidavit will suffice. So please come back with a report on the next occasion. I'll deal with the matter.
Lords,
This doesn't need a very long hearing.
Lords.
My lord, Annexure B, my lord. Map.
What?
Can you look into the
Yes,
map?
you have recorded that, you have stated that there is an encroachment. This is PWD road.
Yes, my lord,
A
PWD.
PWD authority may be directed to take steps.
But the,
You do not
PWD,
want
municipality, PWD কিছু করতে
you
পারে
do
নাকি?
not want to come back with a report.
Lords.
Yes, if you say you do not intend to, I'll record, I'll dispose of the matter. Do you want to come back with a report or not?
Lords, I will file a report.
Come back
Lords,
with-
I will file a report, Lords.
You'll file a report.
Lords.
A report in the form of affidavit submit, report. This is not in the form of affidavit, sir. It was a direction of report in the form of affidavit. Please come back with a report. I'm not receiving this. I'm not taking this. Learned counsels for the respondents seeks extension of time to submit the reports in the form of affidavit as directed. Paragraph, let the matter appear under the same heading on 22nd September.
Lords.
prior report may be.
Please serve advance.
Lords.
22nd September, reports in the form of affidavit.
By both the state and the by the,
Yes, yes.
municipal corporation.
The state's report should be sufficient. If the municipality wants to come back, let them come.
Item 12. My lord, Rameshwar Sinha is appearing before the behalf of the petitioner. My lord, his father-in-law passed away. My lord, I am praying for not this week.
Who is appearing for the respondents? On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 6th October.
Lordship, in item number 13, I am on behalf of the petitioner, Lordship. With your Lordship's permission, I am filing affidavit of service. Lordship, the brief,
Respondents are served.
Lordship, the brief fact of this,
Please. Union of India is also there.
Lordship, Union of India, Railway Department. কোনটা?
Central government officials, you cannot serve directly, isn't it? You have to serve through the office.
Through office.
You've not done that.
Lordship,
Yes, sir, but
actually,
SUVRA
Lordship, this is a change brief, Lordship. The previous advocate has done it, Lordship.
So why don't you serve and come back?
So, Lordship, kindly give a direction to serve. And kindly, Lordship, give a direction to serve and kindly give a short date, Lordship.
The state has been served, I think, isn't it?
Yes, officer in charge has been served. And BL and LRO office also has been served, Lordship.
Serve the state afresh. Please serve the Union of India and come back.
Lordship, but Lordship, actually, I heard from my clerk that when my clerk tried to serve the copy of this my petition to the Union of India, the Union of India refused to receive the petition because
When did you try to serve?
11 Strand Road. And that's why, Lordship, the chairman railway board has been served, Lordship.
There is a circular, very recent circular which says that you have to serve the office of the Union of India.
That means
Not the office of the
Strand,
ministry.
11 Strand Road. Lordship, so,
Try once again.
so Lordship, kindly mention it in your order, Lordship. Then by strength of your Lordship's order, I will serve again.
Affidavit of service. None appears to have the state respondents despite service. Paragraph, since service upon the Union of India, since service upon the first and second respondents is not complete. Comma, let the matter stand over till 25th September.
20. Huh? Sorry, 26.
26th.
Lordship, may I be given one indulgence, 26th September?
Okay.
26th September. And Lordship,
26th.
26. And Lordship, kindly mention that the Union of India will receive the same because the office of Union of India.
Cannot be. How can I direct them to receive?
Lordship.
14.
Lordship.
Yes, service.
Malay, I've served the London.
As usual, S1 number 2, mineral development.
Copy not served.
I've served.
Second respondent.
Every service is there.
How are you appearing? Then
Told by the private respondent that they are you
by way of a mutual arrangement.
Actually, previous, this is not the first matter.
This is not the first matter, your lordship.
Earlier, all occasions, has been served upon me, I appear. They don't choose to serve me, there is no restriction. But this one number 2.
Yes, Mr. Shamanta, have you served?
Another matter also, they are not adding the respondent, they are disputing the hearing and
This
they
is
are
not
not
the
the.
first time.
Kindly consider the affidavit of service.
I am for this state, my lord, on the previous occasion, my lord, as.
Iris of the,
Please.
Yes, challenge. To the Advocate General. Now Advocate General on behalf of Advocate.
Still I am appearing on behalf.
Virus is challenged.
They have challenged the virus of the.
West Bengal mining policy of 2021.
No.
So my lord, I will pay my lord one. Yeah.
Accommodation be given.
The learned advocate general has been served, I find.
Yes.
Allegation is made, I have not served. Kindly see the affidavit of service, ma'am.
There is, here it is not there. Where is the service upon the?
I have not done that. Your lordship, kindly see the affidavit of service.
The earlier affidavit of service.
Yes. Today is express affidavit of land advocate general. The other affidavit of service submitted, madam. Your lordship can see.
State is served. The AG is served.
WBMDCL কত নম্বর আছে?
Then who is right and who is wrong?
Where is the service of the mineral development?
Well, I have served the affidavit of service. These are the
Respondent
postal receipt track report.
Track report is, these are the earlier dates posted.
Yes.
This is on the private respondents.
Yeah, but I have, they say he is not received.
No, private respondent, I said.
Please. No,
I
no.
said
The
the
mineral
respondent number
development
2.
has not been
Mineral.
served.
That has
The
been
respondent
served.
number 2.
Been served. The mineral
Well,
development has
yes,
not
yes,
been
no.
served.
I'm-
Where is the service of the mineral development?
I said in a same matter and the earlier occasions they had not served.
This is not the first time.
I do not find any service.
Earlier, at least on 3 occasions, I pointed out that copy was not served.
I survived.
After my appearance, it was served upon me.
One day I was sitting at the Chief Justice rooms also. This matter was going and this order. I had intervened and immediately I took up the hearing and the matter was disposed of. Like this type of situations was arised earlier occasions.
Shamanta, there is no service on the mineral
The
development.
affidavit of service was the private response served.
Please show me, please show me.
Private,
where
I'm
it
not
is.
representing private respondent. He is saying no private respondent.
Mineral development, not the private respondent. There is no service on the mineral development. You have not served the mineral development, I'm sorry.
একটা তো কপি সার্চ করে
দিন আরেকবার সার্ভ করে
Since the second respondent has not been served, comma, the petitioner is directed to serve
I
copy of
never
the
appeared for-
petition along with annexure thereto upon the second respondent and file affidavit of service on the urgent date. Paragraph, let the matter appear under the same heading on after vacation.
My lord. Now, today I am serving my land friend.
I think you have to serve the office. Can you receive directly individually? I don't think so.
Lordship, that I can receive, Lordship, kindly record it or
Let the direction remain.
They're going to address to you.
20th November.
It was
addressed to me, but not sir.
It was addressed to him, but could not be served. I have forgotten. But addressed to him.
That is
Date
important.
was
No, I am not on that.
2023.
Addressing is
My
not
name
important,
was
service
written
is
on the
important.
letter, but it was not sir.
Anyway, please serve in the meantime. You've received a
I have
copy.
received.
So 20th November,
My lord.
My lord,
20th November.
my lord, kindly. Well, I have deposited the entire amount 2 crores.
Virus is under challenge.
My lord, your lordship, kindly,
Some
sir,
given-
kindly have some sympathy from my client, my lord. I have deposited the entire amount 2 crores.
You have no stand, your lordship. The lease date also over. Lease period over.
10th October.
He is no in existence.
10th
10th
October.
October.
10th of October.
My lord, I am for the petitioner, my lord.
Chief disposed doctor.
Have you served?
My lord, this is the all are served. my lord. Private respondent and all respondent. My lord, petitioner is
Give me a
the
minute, give me a minute, please. Mr. De, may I request you to appear? Please serve a copy of the
Yes.
requisition for Mr.
My
De.
lord, this is the I am the owner of the land. My lord,
Yes.
in front of my land. Acha. In front of my land, my lord, the private respondent constructed a house and running the business upon the PW's land. My lord, this is acquired land. And my lord, my ingress and egress are blocked in construction of the house of the private respondent. Then I am representation before the concerned engineer, and my lord, he is not till consider this my application, my lord.
Page,
Page, my lord. Page 29
that will be considered?
Yes, ma'am.
Mr. De?
by
Affidavit of service.
respondent number 6 and 7, my lord.
One can consider. Affidavit of service.
You
Paragraph
can-
none
yes,
applies for the
don't
respondents despite service. Mr. De, who is present in court,
6.
regularized court, copies of his direction.
7. Assistant engineer.
Paragraph, the petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD land adjoining his plot, comma, thereby obstructing his egress and ingress. Stop, the petitioner submitted a representation in this regard with the concerned authority on 1st April 2023, which is yet to be considered. Stop, the petitioner prays for a direction of the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the 7th respondent be directed to consider and dispose of the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 7th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents in accordance with law. Disposed of. Next.
Yes.
I am appearing for the state in this
But I'm the
matter.
petitioner.
No,
Well, not required, kindly, but there was unauthorized encroachment by the private respondent. I lodged complaint, thereafter approached this honorable court. This honorable court directed the authority to consider. The authority initiated proceeding. Order was passed, challenging the same. The private respondent approached this honorable court. Your lordship granted leave to file statutory appeal. The file statutory appeal under the Highway Act. Appeal was dismissed. Demolition took place. While demolishing the structure, it was found that the part structure is under the PWD, and the part structure they have constructed filling up a water body. Now that part structure is still remain. To that effect, I made an application to the concerned subdivisional officer. My only prayer, let it be considered after giving opportunity of hearing.
Respondent number 7.
Maybe.
So far,
Page 43 is my.
he is also appearing for the private respondent. My lord, so far as this matter is concerned, my lord, your lordship, this is the forwarding request from the subdivisional officer to the BDO, my lord. Your lordship kindly see.
My lord, kindly sees under which, first of all, in this petition, nothing has been annexed, my lord, as to whether requirement was there. First, kindly sees page number 53, the subject matter under which they have said that to consider the representation.
Please give me a minute.
Supplementary benefit. With the court demolition order. This is the demolition order.
Next,
Appellate authority.
No. Order that.
This is copy of the application given before the.
Yes, my lord.
SDO,
Yes.
I think.
This is my supplementary affidavit, the order passed by the appellate authority, dismissing their appeal.
Served
we
copy.
have not received it. We have
Have you served?
Not they refuse to receive. That is my instruction. They refuse to receive. It is on record. On the basis of the dismissal of the appeal. This is the notice of demolition. Demolition took place, and the remain part structure is still there, which they have constructed.
Have annexed all these documents with the supplementary.
Yes, yes.
Submit your supplementary affidavit, serve copies to the
My
respondents,
lord.
and I'll take up the matter on the next occasion.
Yes, ma'am.
Because
Not required. I am praying for consideration of my representation, my lord.
Let me hear his
My
submission.
lord.
Yes.
is page number 53 was their representation. Means what
Are you denying the fact that has been submitted by learned counsel?
under which provision of law they have come before this?
Have you filed a writ petition challenging any of the orders?
Mm.
You have not.
Mm.
This is the representation.
So the respondents cannot buy time before this court, sir. I'm sorry.
They have paid for under the public unauthorized occupancy, public premises unauthorized occupancy Act
Yes,
1970.
yes.
But in the abutments of the plane, they have paid for West Bengal under the Act of 62 miles. Kindly sheet their abutments and kindly see the
Page
case 53 subject.
and that I've seen. That I've seen.
Now, my sees and my lord.
Where?
My kindly sees page 7 of the replay, para 10. First of all, they are adjacent owners. We have transferred it. Page 10, my lord.
Page 7.
Page 7, para 10, my lord. Under which act they are paying, my lord? I fail to understand.
In the plain, you have, in the writ petition, you have stated 62 Act. And in page 53, you have stated 71 Act, the Central Act.
No, that is inadvertently made. The fact remains there is unauthorized structure.
This is technical.
This is technical.
Because the SDO deals with both the acts.
Yes,
both
madam.
the unauthorized construction.
Yes, madam.
Has been mentioned under that. No document has.
I have all the sympathy for your client, sir, who is about to be removed from the plot.
He is the answering response.
Yes, please serve the supplementary affidavit
He-
today.
My lord,
I will
sir.
put
He
up
is
on
the
Monday.
respondent. Ma'am.
On
I'm
my
appearing for the.
On my lord, next Monday, my lord.
Let me see. You are serving, you are.
My lord, I'm serving, my lord.
You are filing it today?
Yes, my lord, I'm fine.
Supplementary information. I'm not supplementary.
Let the
Milord-
documents remain for a few more
Milord-
days.
If you, with your lordship kindly, Milord, I'm submitting, Milord. I come to know that they have filed a supplementary affidavit. I am not,
They are serving copy.
no, Milord, I have not been served. So,
They are serving it here now, sir.
no, Milord, I have not been served.
They are serving it here and now. They do not claim to have that they've served it.
Oh, sorry.
Yes. Supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph copy of the affidavit is made over to learned counsels for the respondents in court this day. Paragraph, let the matter appear under the same heading.
May I have your lordship kindly to file an opposition against this because this they have, I don't know why,
It's not required. No liberty is granted.
because they have already, Milord. If your lordship kindly allow, since your lordship is fixing the,
Required in this matter. I do not feel there is an opposition necessary.
because already, Milord, if your lordship kindly take look the order they have, which they have annexed to the supplementary affidavit, Milord.
Yes.
Milord, in respect of this matter, they have filed another writ petition. By that, by this honorable court, an order was passed and thereafter the appropriate proceeding was took place. And yes, Milord, I'm submitting, Milord. Thereafter, the authority concerned have taken possession of that particular portion. But this is the same land they have come before this.
There
So
is
therefore,
another
I would.
portion which doesn't fall within the highway. It falls within the 62 land. It's government land, but not the highway.
No, this is not, this is my purchased land. Milord, if you lordship, I could show from my document. I could show from my document. I have purchased this land, Milord. That is why I would like to file an opposition.
The authority will give you an opportunity of hearing.
But if your lordship kindly allows me,
No, I will not allow.
since they have already taken, Milord, this particular portion has already been acquired. If your lordship kindly take a look to that.
Not the particular portion. This is with regard to some other portion which is government land, not the PWD land, sir.
No, Milord, that is not that question. If your lordship kindly, since, Milord, if your lordship kindly allows me, I would place those documents. If your lordship kindly.
I'll allow you
So I would like to place those documents by way of affidavit. Kindly allow me.
to approach the authority, not this court.
If your lordship, your lord,
The next date. 15th
15th
September.
15th September.
Action is required. Make your submissions on the next day. Not mention matter. Mention matter gulo kintu. This is not under the mention matter. This is new. Same. Yes. Next.
Beautiful.
Item number 17.
My lord, I am appearing. Straight. Microphone. Who is appearing for the state? You are appearing? I am appearing. There are private respondents?
The Paka Road.
There are
And my
private
lord-
respondents?
Yes.
Have you served?
I have stopped. And my lord, unauthorized construction is made on the ingress and egress of the petitioner, and therefore he made an representation to the subdivisional officer.
PWD
My lord.
road?
My lord,
PWD road?
no. My lord, it's
Land,
government land.
under the 62 Act.
Yes, my lord. And the petitioner made a representation to the subdivisional
Service
officer.
is not complete, sir.
My lord,
Service is not complete.
my lord, service completed.
Have you checked?
Completed.
Have you checked?
Delivery confirmed.
Please come to page 6 of your track report. Page 6
Well,
of the affidavit.
This is not the another track record. My lord,
এটা দেখিয়ে দিন। Give to serve and come back. Yes,
My lord, police give me a report, my lord, totally civil in nature, my lord.
the next page is my lord, delivered.
Family,
Next, delivered.
family members facing
Damodar,
great trouble.
And it delivered.
this is a different person. Please check the names.
Different portion.
Respondent number 7.
Yes.
So please complete service and come back.
My lord, I will take track record, my lord, today. My lord, it is making tomorrow, my lord.
No,
My lord, tomorrow.
no, complete your service and come back. You have not taken the track report till date. Since affidavit of service. Since service upon the 7th respondent is not complete, comma. Let the matter stand over till. Please come back up after service is complete. 14th September, next week.
My lord,
14th September. Please serve and come.
my lord, the same status, my lord.
Let us see. অনেকদিন ধরে পড়ে আছে এখানে ভাঙা।
এই এপিডিবির সার্ভিসটা ফেরত দিন। এপিডিবির সার্ভিসটা ফেরত দিন। কোনো ক্লেমেন্ট auction দাও auction। Well, next matter is shame matter. Shame, analogous matter. Service is completed.
No, Lord, I am
Service is completed.
18, এটা 18. Lord, I am appearing for the state respondent in this matter.
Item number 18,
My lord, 5 private respondent delivered.
He is appearing for the private. Yes,
And my lord,
you are appearing for?
number 6, 7 and 8 9 and 10 are outsider who has been falsely implicated in.
So you are appearing for 6, 7 and 8. 9 and 10 is served.
everybody are my lord sub, and they have received it.
Give me a minute, please.
Outsider was the
এটা নেবেন একটুখানি, এটা নেবেন 18
Yes, it's all served.
My lord, the ingress and egress is obstructed by unauthorized construction. And my lord, the petitioner made a representation to the subdivisional officer, Tomluk subdivision. My lord, kindly see page 28. Page 28. Analogous matter. My lord, the same
Government land.
government.
Your lordship, kindly come to paragraph 5. Kindly come to it. No, that's just it.
Yes.
It is stated that before the purchase of the aforesaid plot of land, it was converted by nature. Therefore, since long being erected residential house, the petitioner and her family members have been residing therein until and unless conversion permission is issued by the Holder Development. He is admitting that he has encroached the government. He himself doesn't.
This is, my lord, this statement is, my lord,
It is a government land.
this statement shows that I am
You
inclusive.
allow it to complete.
Not if it is without conversion, then it under the specified act, Land Reforms Act 2R2, he has to go to the land tribunal.
Why? Why? My lord, the petitioner's premises is adjacent to the,
Without the paragraph 5.
adjacent to the public. And my
You
lord,
have raised construction without conversion of the land. You say prayer for permission was made.
and
Where is the
permission has already been given. Permission has already been given, my lord. Kindly see this.
It's not annexed to the writ petition.
It is,
And that has not been annexed in the writ.
my lord, conversion is, will take a time.
Then.
And my lord,
they are
after all, my lord, the frontage of the petitioner's premises is, my lord, constructed unauthorized construction. My lord, therefore, he made an application before the subdivisional officer, and my lord, subdivisional officer is not considered it, and therefore, my lord, the petitioner has come before your lordship for necessary direction. For necessary direction.
Please serve a copy of this letter to.
My lord, I will give.
Blood, your lordship, kindly come to the affidavit portion. Page 15. That the statement contained in paragraph number are, to my knowledge, those made in paragraph number 2, 3 and 5. I am emphatically emphasizing that this one paragraph 5 and 12 are derived from record
Yes.
But record if it is there, it is not annexed in the writ petition. And the concerned authority should have been included in the writ petition. That also has not been done.
You are being hyper technical, Mr. Ganguly. Please come on merits. After filing of the writ petition, this permission has been accorded.
That is not in my knowledge.
Please
Well,
come back with a, please come back with a one-line supplementary affidavit on the next page.
দেখাও একটু দেখা।
Bring this on record,
দেখাচ্ছি, এই
please.
তো দেখে নিন।
Please bring this on record by way of a supplementary.
My learned senior friend will see this. My lord,
Private respondent regarding encroachment of the boundary. It is not a case of a encroachment of government land. Kindly see the report filed by the PLRO and my lord police before the subdivisional magistrate. In the proceedings under section 144 subsection 2 of CRPC. Kindly see, my lord.
kindly direct to the subdivisional officer, my lord, who will the authority, my lord, will see this, whether there is any encroachment or not. He is the authority.
Mr. Ganguly, I think you need to file a report in this case.
I don't know.
No, please don't take that.
Let the state, this is the state's report. Let the state come back with the report.
But may I একটু দাঁড়াও দিচ্ছি বাবা দিচ্ছি।
Yes.
May I humbly request your lordship, let the office of the Haldia Development Authority also be included. Let them come forward with their report.
Why, my lord?
In this case, they are not required necessary parties.
Why not?
Your report will be sufficient. They are not necessary parties in this case. Let the state come back with the report.
Permission has been granted by them. That's why my
Let that come by way of a supplementary affidavit. Let the state come back with the report.
I remember the question.
Affidavit of service.
All disputed question of fact.
No disputed question of fact. Only, my lord, government land is encroached by way of construction, and my lord, in
Counsel
front of.
for the petitioner seeks on prayer of
Consider
on
the
prayer of the
matter to the
petitioner,
other
liberty is granted to use a supplementary affidavit annexing the document indicating permission granted to the petitioner for development of the property in question. That is the language in the permission.
Yes.
Yes, I will have.
Paragraph learned counsel for the state
I'm
respondents
supplementary দিতে বলছে তো, আমি কি
seeks to submit a report in the form of affidavit in this regard, in this matter. How can I take a report like this? Let the state come. You can assist the state with the report if you want. Let the matter appear the same day.
Yes, yes.
Let the matter appear under the same heading on 15th September, I said.
14 September.
আগেরটা কবে দিলে?
কবে 14th
14th September.
14th
September.
Not, may I have the copy of the supplementary affidavit?
Yes,
in
yes,
advance
my
for
lord.
this?
I will, sir.
আজকে দিয়ে দিস যদি পারে।
আজকে supplementary টা করবো।
কপি দিয়ে দিস।
হ্যাঁ, ঠিক।
Next.
Number 19.
I am for the petitioner.
For the lordship private.
My lord,
Whether this petition is.
Please switch on the microphone.
Whether lordship this petition lordship is maintainable because lordship this is relating to lordship the private land. Land was lordship rented with the private respondent by the father of the petitioner lordship. I am handing over the
Land
lordship
was?
by the father of the petitioner. And kindly consider lordship the third line of this agreement. 2010 lordship it was entered into by the father of the petitioner and the private respondent except lordship private respondent number 8. Third line বর্তমানে দ্বিতীয় পক্ষ আমার উত্তর দখলি থার্ড লাইন আছে পিডব্লিউডি বাস সংলগ্ন ভূমি আমার খরিদার সম্পত্তি হইতেছে।
The father is Sottokinkor
সত্যকিঙ্কর মাইতি
Yes.
who rented the land lordship to the private respondent,
My lord, it is not the land of the,
Complete, please.
and in the third line, Lordship, it has been stated by the father that it is his own purchased property.
What is the schedule of the property here?
Plot number, Lordship,
No schedule.
386, plot number 386, 366 jail number 36 Kasijora Mouja. 386, plot number, paragraph 2 of the writ application.
Jail number 360, Ashkura. Yes. This is plot number 386.
386.
And the writ petition pertains to plot numbers 430 and 431.
Sabek plot number 386, Lordship, paragraph number 2. Corresponding to LR plot number 431, Lordship. Last third line.
A portion was rented out.
Portion, they are subsequently, Lordship, the land was used for, Lordship, for the preparation of embankment. And now they are, Lordship, claiming that their ingress and egress over the, Lordship,
And my
said
lord-
embankment has been, Lordship, blocked by the private respondent. But prior to that, Lordship, that was rented.
Yes, but this is with regard to portion of the petitioner's land.
yes,
The petitioner says that the land in front of the petitioner's land is
Yes.
being
That has not been encroached, Lordship.
yes,
That has not been encroached, and I have, Lordship, instruction, Lordship, that they have also made a representation before the authority that they are using for their, Lordship, putting their utensils and something. And anytime, Lordship, government required, it is not encroached. The construction, the temporary construction is over the,
material on a land which is not yours is encroachment.
no, Lordship, the construction, in Kacha construction, which they have asserted, that is over the, Lordship, private land, petitioner's land.
These settlements are in respect of the portion of the petitioner's land,
Petitioner's
which
land.
is not in dispute.
Not in.
The dispute is the front portion of the petitioner's land.
But, Lordship, what
So
has
let
been
the representation be considered.
I
You'll
have
be
no
given an opportunity of hearing.
opportunity of hearing. Because the
Yes.
construction has been made over the, Lordship, kindly record my submission. The construction has asserted in the writ application and the representation, Lordship, which, Lordship, is different from, Lordship, our, Lordship, agreement. It is, Lordship, they are stating, Lordship, that we are, Lordship, on the PWD land. It is our claim, and from the, Lordship, agreement, it
Yes.
will be apparent that
my lord, it is.
their
irrigation
father,
and
Lordship, has
water.
been settled their plot of land in favor of us, Lordship. Now, without filing a civil suit, Lordship, they are trying to, Lordship, evict us by way of this writ application.
You are on public land, on government land. There, the petitioner's claim is that you are encroaching upon government land.
Yes,
Nothing to do with this private.
Private
in the
land.
writ petition.
Yes.
The petitioners claim to be recorded because the petitioners are still owners.
Owners,
Yes,
they can file, Lordship, suit for,
recorded owners in respect of the plot in question and submit that the private respondents have encroached upon government road adjoining their plot by raising unauthorized construction therein, comma, thereby obstructing their egress and ingress. The petitioners submitted separate representations before the concerned authority on 21st November 2022 Paragraph annexure A, annexure P4 to the writ petition. Paragraph, bracket and paragraph bracket, annexure P4 to the writ petition, which are yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representations at the earliest. Paragraph, it is submitted on behalf of the private respondents that the father of the petitioners let out a portion of the plot in question in favor of the private respondents by execution of agreement on 1st January 2010, and the respondents are in possession of the said rented portion. Paragraph. Learned counsel for the state respondents submits that the fifth respondent, subdivisional officer,
Third respondent. The subdivisional officer.
third respondent, the third respondent be directed to consider the representations in accordance with law. Third or fifth? Third.
Third, my lord, third.
Paragraph. Since the petitioners allege encroachment of government land adjoining their property by the private respondents, the writ petition is disposed of, directing the third respondent to consider and dispose of the representations submitted by the petitioners dated such and such, within bracket annexure P4 to the writ petition, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law.
Kindly Lordship record another line, Lordship, that we have not enclosed the Lordship PWD load, Lordship. Government land, Lordship.
Hey, what are you?
We have the private respondents.
Permission আমরা চেয়েছি, আমরা এখন কোনখানে রিলিজ করি।
Stop. The respondents have not encroached upon any portion of the government.
And we have sought for permission before the concerned authority.
Where is that document?
It is not.
Place it before the authority. Disposed of projection.
Grateful.
Next matter is same matter.
Who is appearing?
Affidavit of service.
20.
20.
But I am for the private.
Affidavit of service. Well, same my lord, page 27.
Who is appearing for the state?
I do not know.
Mr. De, may I request you? Please serve a copy to Mr. De.
Yes.
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 Anything, any submission? to
My lord, the petitioner also encroached the government. My lord, kindly see the photograph of the.
Have you
Well,
approached any authority?
Yes, no,
Have
I
you
have
made
not,
any complaint?
no, I have not complained. My lord, the petitioner also complained.
No, my lord.
Have you made any complaint against the petitioner?
No,
Then
a proceeding was initiated under section 144(2), my lord. A report was.
Well, if his submission is correct, my lord, then my lord, I have no objection. If there is any encroachment from the side of the petitioner, that should be demolished.
Yes, madam. That
let all
should
the
be
evidences be removed.
Yes.
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 Affidavit of service. None appears for the state respondents. Mr. De, appointment regularized for copy service direction. Paragraph. The petitioners. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have faced unauthorized construction by encroaching upon a portion of government land adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on 27th February 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the private respondents that the petitioner has encroached upon government land in front of his land.
Government land. Government land.
Government.
Government.
The petitioner has raised unauthorized construction, you see.
Yes, two-story building.
The petitioner has encroached upon government land by raising unauthorized construction therein. Paragraph. Learned Counsel for the state respondents submits that the third respondent.
Yes, well.
Third respondent be directed to consider the representation in accordance with law. Paragraph. Since it is alleged that both the petitioner and the private respondents have encroached upon government land, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner, dated such and such, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Stop. In the event the petitioner is found to have encroached upon government land or any portion thereof, necessary steps be taken against the petitioner for necessary steps be taken for removal of all encroachers therein and demolition of the unauthorized construction made in the government land within the stipulated time frame.
My lord, one indulgence, my lord. Earlier 2 matter, your lordship seeks on 14th. My lord, on that very day, my lord, I have an engagement with doctor, my lord, neuroscience. And
You
there,
should have said this when the matter
I will, my lord, convey this matter. Will kindly make it a 15 by in lieu of 14. I convey, my lord.
Please convey them.
Yes, sir.
Go to the 15th. Item numbers,
Item number 17 and 18.
but please inform them.
Yes, sir. I will inform.
Go to 14 আছে না? Go to 15th. Yes. Next.
Issue item number 21, and for the petition. Lordship, in this matter, petitioner is the
Please wait for a minute.
21.
Lordship, in this matter, petitioner is the sole and absolute owner of the plot of land by a virtue of a registered deed of sale. What I have to file this instant writ petition, Lordship. Lordship, kindly come to straight away in the impugned order in page number 74, issued by the subdivisional officer.
So are you appearing for all the respondents? Are you appearing for all the respondents?
Didi.
WBHDCL? Six and 7? Have you served 6 and 7?
Main answering respondents are state respondents, Lordship.
Maybe, but you've implemented them. Yes. They are the required. Where is your service? The postal receipts?
Postal is possibly
Not there. So I cannot make out who is served and who is not served.
You should then allow me to
You
serve
need
it
to come
once
back
again.
with the postal receipts. It
But
appeared to be.
their presence is not, I should serve, but Lordship, there is a legal point. They cannot serve this notice under the Act of 1962.
Maybe, but you have to either expunge their
Lord-
names or
Lordship.
serve.
Lordship, any date fix up, I shall come back.
Since service upon respondent number 6 and 7 is not complete, comma, let the matter appear under the same heading on 20th September.
20th September.
You can complete service by then.
Lordship. Deeply obliged. Only to Lordship 6 and 7.
Two,
Only to Lordship 6 and 7.
6 and
Deeply obliged.
State is appearing. 22.
For the petitioner, my lord.
The private respondent number 9 to 12.
Enforcement, my lord. Over my lord, it's a PWD land, my lord, enforcement in front of my house, my lord, before the highway. My lord, I have already made representation, my lord, page number
You're for the private respondents.
12.
State,
For the state.
yes.
Nothing has been done, my lord. The representation was done 3 months ago, my lord. For demolition, nothing has been done, my lord. According to the highway, section 10 of the highway act, I have made the
Where is your
representation.
representation?
My lord, page number 12.
Demand
12
justice.
onwards, demand justice.
12 is a demand of justice,
No representation.
not a representation.
I demand justice. my
Where is your representation?
lord. There is no representation. The advocate letter, that's done, my lord.
Cannot be considered.
There is no representation.
There should be a representation.
So, my lord, demand justice. Demand justice.
That is called a demand of justice.
My lord, it's a fact, my lord, it's a fact because, my lord, let them say, my lord, what happens, the state is there, my lord.
Yes.
Kindly direct them to approach both the authority through directly by the.
File a comprehensive representation before the authority. Ventilating your grievance. They'll consider within 3 months. Right? Yes. You'll be given an opportunity of hearing.
Yes.
And
The petitioner is aggrieved by unauthorized construction made by the private respondents on PWD land adjoining his property, comma, thereby obstructing his egress of funds. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard. And
by 2 days, my lord, supplementary because everything is there, my lord, this should be done by 2 days, my lord.
what should be done by 2 days?
Representation, my lord, because demand justice is there, my lord.
You will file a representation within 2 days. That's what you're
No, no,
saying.
I will send by, I will send by 2 days, my lord.
Yes.
My lord, I
In that case,
Will be considered.
highly consider, but I have to.
What are you saying, sir? Submit a representation before the authority, they'll consider it within 3 months because if encroachment is detected, section 10 proceeding has to be initiated. That will take some time, isn't it?
I know.
The entire proceeding will be completed within 3 months. Good. And prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the third respondent
Yes.
third respondent be directed to consider the representation in accordance with law.
Fine.
Paragraph, in view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the third respondent within 7 days. Within 7 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of.
At least.
Next.
28. Mention
23.
matters, item 228.
Mention matters from 12:30.
My lord, may I humbly pray, my lord? This item 23, just the next item, my lord. And I'm praying for an adjournment because I am led by my senior Shakko Sen, my lord.
Come back on the next day. It's not being called today.
My lord, be pleased to
You
fix the
have an
matter,
automatic Adjournment.
my lord.
You have an automatic adjournment. It's not being called today.
Yes, ma'am.
Next occasion.
My lord,
228.
my lord, just, my lord, one indulgence, my lord, if your lordship will keep it after my lord, next week sometime, my lord. Because, my lord, item 23, my lord, he's seeking an
Sir.
adjournment, my lord, it'll run in the list on
It's not
Friday.
called, it's 228 now. Come back on the next day. 228.
After these mentioned matters, my lord, will again follow the list.
If there is time. Yes.
My lord, this is my affidavit of service.
Sir.
No, my lord.
It's only the state.
Yes, I am representing the state. My lord,
You are representing the
exactly,
state?
yes. Just few minutes before we got the instruction, my lord, we need to print it out. Kindly give me half an hour, my lord.
Innocuous peer. Because my lord, against my non-consent of the settlement, I moved before the tribunal, land reforms tribunal. Now I was directed to withdraw this and made a representation before the appropriate authority. But I have gone through the representation, and I find that a comprehensive representation is required to be made before the authority for consideration. So my prayer is, my lord, I may be allowed to make a appropriate, a comprehensive representation before the authority, and who will dispose of my representation within a certain period. If you lordship kindly turn to.
You shouldn't be having difficulty with that.
My lord,
I'll not go into merits of the case.
yes, my lord,
Petitioner
I,
seeks to submit a representation and is asking for consideration by you. That's all.
my lord, why they are not, why the authority is not considering their prayer, that we need to know, my lord.
My lord, then they have to inform
LRTC,
me.
there is,
Then they have to inform me that I will reject my application.
my lord, kindly allow me for half an hour time, my lord. I will print it out and will take
Stop.
it. Happen,
My lord, so my lord, I will come back.
I'll give you a date.
my lord.
Affidavit of service. Paragraph on prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14 September.
My lord.
My
A
lord,
very short issue.
my lord, my lord, my lord. Grateful, my lord. 29.
My lord.
Same heading হবে না, আমি ভুল করলেও under the heading motion. Mention matter এসে গেছি আমরা। হ্যাঁ, এখন কিন্তু সব under the heading motion চলে যাবে, আর mention এ থাকবে। হ্যাঁ। Mention matter আছে। যে mention matter আছে তো, সব under the heading motion হয়েছে। আর এখানে থাকবে। Under the same heading. Mentioned গুলোর under the heading motion. Unmentioned become. Anyone appearing?
I'm for the petitioner, lordship.
You're for the petition?
Petition.
Service?
Lordship, on the earlier occasion, the
Sir?
state had.
Mr. Ganguly was appearing for the state. Where is Mr. Ganguly now? Did you mention upon notice? No. That's the difficulty. It's not aware. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 28th September, 28. No. বলছি না, ভুল হচ্ছে আমার, হ্যাঁ। Under the heading motion on 28th September. Paragraph, the petitioner is directed to serve notice upon the respondents intimating the adjourned date.
Grateful, lordship.
8th September, 28 তারিখ।
230.
But I beg to appear on behalf of the petitioner. Notice today, on the last day, my lord, your lordship kindly remember yesterday, your lordship took up this matter. My lord, your lordship's last order. Mr. Washim Ahmed appeared for the state respondent. Yesterday, my lord, he took time through his junior My lord, this is the letter, my lord, by virtue of which, my lord's last order was being communicated to them, since they were not present at that time. My lord, kindly takes up, my lord, this is an Act 2 acquisition which has not been completed. I approach this honorable court. This honorable court directed, my lord, page 24. Page 24 is the, my lord, order passed by this honorable court on the last occasion, my lord, where, my lord, I filed the petition.
Hearing this matter in absence of the state will not really serve your purpose.
My lord, kindly see, my lord, they have decided everything pursuant to the order passed by this honorable court. Kindly takes up, my lord, page 33. This is the reasoned order. But I will not trouble your lordship. Page 34, last paragraph, your lordship will see, my lord, that they themselves have stated for the purpose of construction of flyover. Page 34, my lord, the last paragraph.
Yes.
For the purpose of construction of flyover, my lord, my property is being utilized, but due to non-deposit of the relevant, my lord, fund before the acquisition authority, the acquisition process could not be completed. And, my lord, they have stated, my lord, the last page, that they are not in a position to revive. I have already, my lord, stated before your lordship that yes, now, my lord, the constitutional bench judgment is there. My lord, they don't have any other option but to initiate a fresh proceeding, either, my lord, under 2013 Act, or, my lord, they will have to, my lord, purchase it. Yes, direct purchase. Both my client is agreeable. Last day, my lord, the learned advocate representing, my lord, the Wasim Ahmed, my lord, he took adjournment. Your lordship also made it clear that today your lordship will pass necessary order. My lord, that's why, my lord, they cannot, my lord, take advantage of this, my lord, in this fashion. My lord, this, my lord, company the director are now, my lord, the hand-to-mouth situation. Their business goes, property goes.
Will you come back on Monday? Just
Yeah.
intimate them. I'll pass an order on Monday. I'll just record that out.
Smart.
None appears for the state respondents despite service of notice. Paragraph, let the matter appear under the same heading on 11th September. Paragraph, the petitioner is directed to serve notice upon the state respondents, intimating the adjourned date. Paragraph, it is made clear that the matter shall be taken up for consideration on the adjourned date, even in absence of the state respondents, if they choose not to appear, despite service of notice.
I'm grateful. Will the notice be kept with the record, my lord, that I have produced today?
Should the notice served upon the state respondents is taken on record.
Great.
No, under the heading we motion. Next. সব গ্রুপ ওয়ান মোশনে চলে আর মেনশনটা থাকবে আমি
তোমার আসবে 11 তারিখ
231.
Anyone?
11.
সোমবার পেনশন ম্যাটার তো হ্যাঁ সঠিক স্লিপ তো দেখছি না হ্যাঁ Ancient matters also on the ground of urgency, it's mentioned and then there is no one. I'll dismiss all mentioned matters if they are not.
I have seen
This matter.
yes, madam. There is a petition landed at
I cannot record the petitioner's name. None appears for the petitioner. Let the matter appear under the heading Group 1 motion on 6th October.
6-10 one motion.
for petitioner.
232.
Made for Lord, I am for the petitioner, my lord. What?
I appear for the respondent, private respondent.
My lord, once the application has been filed, under the my Lord West Bengal Highways Act. However, thereafter direction was given that no, it will come under that property belong to the district board. And it will appear from the my lord, kindly see the annexure. My lord. Property belong to the my lord, the district board. It will appear on page P1 annexure 16. Kindly see my lord. Page 16, 16.
Page 16.
16, my lord.
Yes.
Annexure P1. The plot that number 194.
Yes.
District board is the my lord, the authority, the owner of the land.
Yes.
However, as there's a constructions over the some portion of the land, alleging that a case was filed by a landed friend before this honorable court. This under the my lord, the for removal under my lord, the West Bengal Highways Act.
No, another.
Alleged encroacher.
My lord, thereafter.
Not the alleged encroachers. Yes.
My lord, thereafter, my lord, the decision was taken by the district school board, the district, my lord, the district magistrate. District magistrate, the order, my lord, it will appear, my lord, from page
36.
Page 36, my lord, kindly come. Page 36.
Yes.
On considering the above facts and circumstances, after careful perusal of the available documents, records, the undersigned hereby direct the subdivisional officer, Hondia, to take all necessary steps for removal of all encroachments from plot number 194 under the provisions of the West Bengal Public Land Erections and Unauthorized Act with the help of the concerned department within 2 weeks from the date of the my lord, communication of this order. This order, my lord, my client, my lord, moved this honorable court, filed this honorable court. Your lordship was pleased to, as the appeal provision is there. Well, kindly the next page, page 37. On prayer of the petitioners, liberty is granted to correct the cause title. The order impugned passed under the West Bengal Public Land Authorized Act is available under section 7 of the Act. Learned counsel of the petitioner submits that the instruction to withdraw the writ petition and take necessary steps for redressal of their grievances before the appropriate forum. In view of above, the writ petition being WPA circumstances dismissed for non-prosecution, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievances. However, my lord, having liberty from the honorable court, we prefer the appeal. The next page, page 38.
Yes.
But when the appeal is pending for consideration with the appeal authority, the impugned order has been passed. It will appear from page 39. My lord, immediately thereafter, my lord, having this order, my lord, move these writ petitions. But as address was not given, my proper address, so your lords will give me liberty to serve the notice upon the correct address. So you have got no order on that date. My lord, I have challenged that. Kindly see the order. So what is my prayer? My appeal is pending for consideration. My prayer is that the direction may be given to the appellate authority to dispose of the same, and till such disposal, my lord, that order cannot be, my lord.
My lord, your lordships granted liberty to approach in appropriate forum. My lord, that was granted January 2022.
Yes.
Now your lordship kindly sees what is the conduct of the petitioner hearing. The appeal which has been alleged to have been preferred. Date is 3rd February 2023.
Yes.
After lapse of about, my lord, 23
No, 23.
1 month. This appeal has not been pursued by them. Thereafter, this order of,
It will be pursued by the court now.
as your lordship, it can be done.
Disposed of within 1 month. Till then, no coercive steps.
Very well, very well. Your lordship kindly do that.
Yes, sir.
So that he cannot pray for any more privilege.
Third learned counsels for the parties. Paragraph, it is contended on behalf of the petitioner that that alleging unauthorized construction, alleging encroachment upon government road, comma, an order was passed by the district magistrate, comma, Purva Medinipur on 19th October 2022. And then alleging unauthorized encroachment by the petitioners, comma, an order was passed on the government road, alleging encroachment upon government road by the petitioners.
Road, no land.
Road by the petitioners, comma. An order was passed by the district magistrate Medinipur on 19th October 2022, directing the subdivisional officer Holdia to take necessary steps for removal of all encroachments from plot number 192 under the provision of the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act 1962. Within 2 weeks from the date of communication of the order. Stop. The petitioner approached this court in a writ petition being WPA 25318 of 2022, challenging the said order, and by an order passed on 24th January 2023, comma, this court held that the order was appealable, the order was amenable to appeal under Section 7 of the Act of 1962. Stop. The petitioners were granted liberty to approach the appropriate forum for redressal of their grievance. Stop. The petitioners preferred statutory appeal on 3rd February 2023, which is pending. Stop. Paragraph, learned counsel for the petitioners submits that during pendency of the appeal,
Section 7. Section
notice has been issued by the subdivisional officer, comma, Holdia upon the petitioners on 27th March 2023, instructing them. A notice has been issued by the subdivisional officer Holdia upon the notice now. During pendency of the appeal, comma, the subdivisional officer, comma, Holdia, comma, by a letter issued to the block development officer, comma, Mohishadol Development Block, comma, Purva Medinipur, on 27th March 2023, comma, instructed the latter, LATTER, to initiate proceeding for eviction of the illegal encroachers with the help of the OC Mohishadol Police Station and the Block Land and Land Reforms Officer, comma, Mohishadol. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since appeal preferred by the petitioner against the order passed by the district magistrate, comma, Purva Medinipur is pending, comma, the concerned authority be directed to deal with the appeal expeditiously in accordance with law. Paragraph, accordingly, the petition is disposed of, directing the, who is the appellate authority?
The divisional commissioner.
Divisional commissioner.
Respondent number?
Respondent number 2. Page 2.
directing the appellate authority being the second respondent herein, comma, to consider and dispose of the appeal within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the parties thereto, comma, in accordance with law. Paragraph pending disposal of the appeal, comma, the pending disposal of the appeal, comma, no coercive steps be taken against the petitioners in respect of the plot in question in terms of the notice, in terms of the letter dated 27th March 2023.
Notes. My
Disposed of which?
The appeal is also beyond time. Within 15 days, appeal has to be done.
Let the appellate authority decide.
ওখানে ওই পয়েন্টে নেবে
Next.
নাম দিচ্ছি তোমরা গিয়ে অ্যাটেন্ডেন্স দাও না রে
233.
চলে যাও গিয়ে খোঁজ নাও
Madam, I am for the petitioner. This is my affidavit of service.
Mr. Dey, your appeal?
The petitioner is a fish production group and they have participated in a tender process for getting 5 years tender for a respective Ramnadighi pond so that they can continue with fish production. But my lord, that participation got late and they did not got the tender. Apart from that, no other person has participated in the tender and the tender process has been not affected. Now, my let it be considered, my lord.
That will be considered.
Let this be considered?
Considered, my lord, in our by giving an opportunity of hearing to us.
Affidavit of service. It is contended on behalf of the petitioners that the petitioners being a fishermen's cooperative society and its chairman, comma, learned about a tender floated by the additional district magistrate.
Yes, my lord.
By the additional district magistrate and the district land and land reforms officer, comma, Murshidabad. At a belated stage, for which they were unable to participate in the tender. Stop. The petitioners further learned that there was no participant in the tender for which the tender could not be proceeded with. Stop. The petitioners seek to participate in the said tender upon, it is there. The petitioners seek to participate in the said tender upon compliance with all requisite formalities and filed and submitted a representation in this regard before the concerned authority on 12th October 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the second respondent Second respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petitioner is disposed of directing the second respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week there. Disposed of it.
Great, madam.
234.
I'm for the petitioner, madam.
Yes.
My lord, the petitioner is a 76 years old lady, my lord. In the year 1978, land of, my lord, 36 decimals was acquired of the petitioner, my lord.
For the minor
Yes, madam.
irrigation corporation, you are appealing.
No, madam. This is a separate set of advocate, madam. They are the answering respondents, madam. They have utilized the land, madam.
Everyone has served, my lord.
You cannot appear.
5 and 10. No, 9 also you're not appearing.
No, 9 I'm not appearing.
5, 9 and 10. Have you served them?
Yes, ma'am.
Yes, served. They are not appearing. Yes, what is the matter about?
My lord, in the year 1978, my lord, 36 decimals of land, my lord, of the petitioner was acquired with an assurance of compensation and a job, my lord, of the family, my lord. Till then, my lord, nothing has been given. No compensation or job, my lord, has been repeated occasions. Several representations has been given, my lord. And my lord, kindly come to page number 62, my lord. Petition number 3311 of 2025 was filed by the petitioner in the earlier occasion, my lord. And
62.
my lord, page 62, my lord, order dated 27th of March 2015, my lord. My lord, here, my lord, the submissions of the respondent advocate, my lord, Mr. Mukherjee, learned advocate for the second line, my lord. The learned advocate for the respondent number 10 submits the respondent is willing to make an outright purchase of the portion of land in question belonging to the petitioner, my lord. My lord, this proposal was given, my lord, but no effect has been given till date, my lord. My lord, old lady, my lord, at that point of time, my lord, with the assurance, land was acquired, my lord, admittedly. But till date, nothing has been, my lord, the petitioner is hand to mouth part of the society, my lord, belonging from and paying for compensation, my lord.
Since I do not find the other respondents,
My lord, they have filed another earlier writ petition. In that writ petition, what is the prayer? Can you see page 7? Page 7.
7.
7 of the writ petition, my lord. They have quoted the prayer of the writ petition, earlier writ petition, my lord. 13, paragraph 13A, my lord. A writ of mandamus commanding the respondents to pay the compensation money to the petitioner for acquiring the land of the petitioner for the purpose of installation of MIC deep well bring such and such. And the B, writ of them commanding the respondent to pay the rent and interest accrued thereon in respect to the usage of the land of the petitioner for the period from the taking possession. These are the prayers, my lord. Now, my lord, this is dismissed by this normal report.
Where is that order?
They have annexed, my lord.
At page number 66, my lord.
65.
My lord, at page 65, my lord, the order, my lord, and page 66, merit, my lord. Hence, I find
Yes,
that
it has been it is dismissed.
my lord, dismissed in want of details, my lord. Hence, I find that in the absence of any details of the material particulars in this petition, petitioner dismissed, my lord, and leave also granted to the petitioner to file an appropriate proceeding, if so advised in accordance with law. My lord, thereafter representation has been given, my lord, and page 67, the LA collector reply, my lord, it appears, may I read, my lord? It appears from the record of this office that there is no acquisition case exists on suit plot. The petitioner is in this application has not also mentioned LA case number. unless acquiring body forwards proposal of to the LA department for acquisition and deposition of compensation money, the department has nothing to do for paying any compensation by initiating a case on the suit plots, my lord. Thereafter representation given, my lord, no.
This is the
Nothing has been
instruction of
considered, my
the
lord,
state
till date.
government is the earlier requisition.
My lord, page 69, my lord.
Self-same prayer has been made out in this petition, madam. Self-same prayer, madam, which earlier has been
Yes, my lord.
dismissed.
Self-same prayer, my lord. At that point of time in the year 1978, land was acquired. my lord.
They were granted liberty to file a fresh writ petition.
Not fresh requisition, file an appropriate proceedings if so advised.
My lord, that has been filed, my lord, and this is the outcome of this proceeding, my lord. Page 67, my lord.
No, 16 is the instruction given by the, my lord, in earlier requisition.
67 is an instruction.
Pardon, my lord. My lord, this representation has been given, my lord, to the appropriate authorities, my lord. All are served.
You know, say directly to consider representation.
My
I
lord,
have no,
these
my lord.
petitioners are laymen, my lord. At that point of time, with assurance of compensation, the land was acquired somehow, my lord. And petitioner is 76 years old lady, my lord. He's
Filed a comprehensive representation because this representation is not very proper. It's not
my
properly
lord,
drafted.
this is all the materials are on before the petitioner, my lord. Records are lying in the departments of the
So
appropriate
you
department.
want this representation to be considered by the authority?
My lord, appropriate order may be passed, my lord, so that the petitioner could get some relief, my lord. This is the second writ petition, my lord, and petitioner is very poor part of the society, my lord. Very poor, my lord.
If there can be a direction for consideration of the representation, that can be done today.
My lord.
If otherwise you want a more appropriate order, a
Hello.
more comprehensive order, in that case you have to just intimate the authority and their presence is required.
That direction may be given, my lord. I will serve my lord notice.
You will intimate them?
Yes, ma'am.
Since service is made, you don't need to serve again. Just intimate them that adjourn date.
My lord.
Mr. Waterman, let the answering authority come before the question. Because there are other petitions were there, so let them come and say.
Yes, ma'am.
Affidavit of service. None appears for respondent numbers 5, 6.
My lord.
7 and 10.
And one indulgence, my lord. But direction may be given to consider the representation with a speaking order, my lord. Appropriate speaking order that will serve the purpose, my
And
lord.
do that
For now, my
no
lord.
further. Wait, so I can dispose it of.
My lord, kindly. With the direction to speaking
None
order. my lord.
appears for respondent numbers 5, 6, 7, and 10, despite service. Paragraph. It is contended on behalf of the petitioner that a portion of the land of the petitioner was utilized by the minor irrigation corporation.
Yes, sir.
Utilized by the state minor MINOR, minor irrigation corporation,
A government of West Bengal entity.
with an assurance of payment of compensation and a job. Payment of compensation and a job, or only compensation?
Where is that?
Payment of compensation.
Both were
And
assured,
job.
my lord. Compensation and job, my lord. Nothing has been given, my lord, till date.
আমরা apply করতে পারি না।
On an assurance payment of compensation and providing a job
আমাদের কাছে concession
to the petitioner. Stop.
আমাদের কি বলবো? না, আগে একটা read করেছিল,
The
self-same-
petitioner has
হ্যাঁ,
neither been favored with compensation,
ছিল,
comma, nor a job by the authority till date.
file an
Stop.
appropriate proceedings, এই proceedings গুলো হয়ে যাচ্ছে। তো বলুন, তারপরে representation দিয়েছে, representation টা consider করুন।
The petitioner filed a writ petition before this court earlier, being WPA number 3311 of 2015, wherein by an order passed on 27th March 2015, comma, a coordinate bench of this court recorded who was the added respondent in that matter? Who was the added respondent in that matter? The corporation?
My lord.
Yes. The corporation was the added respondent. Number 10 in the earlier writ petition.
1 minute.
that the corporation,
Corporation.
yes, corporation expressed its willingness to
Minority.
purchase the portion of the land of the petitioner utilized by them. The writ petition was dismissed in absence of any detail or material particulars, and the petitioner was granted liberty to file an appropriate proceeding in accordance with law after providing necessary material particulars and details in respect of his grievance. Paragraph, in terms of the said order, the petitioner submitted a representation before the Secretary, West Bengal State Minor Irrigation Corporation, within bracket MIC, on 23rd February 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the
The
earliest.
speaking order, my lord, and opportunity hearing of may be given.
I'll pass that on. Paragraph, it is submit, paragraph. Upon consideration of the submission made on behalf of the parties, the writ petition is disposed of, directing the Secretary, West Bengal State Minor Irrigation Corporation, within bracket MIC, being the ninth respondent herein, to consider and dispose of the representation submitted by the petitioner dated such and such within 2 months from the date of communication of this order, upon affording by a reasoned and speaking order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, since the ninth respondent is not represented, the petitioner is directed to serve a copy of this order along with a copy of the representation upon the ninth respondent at the earliest. Disposed of.
My direction may be passed upon the divisional engineer, my lord, because he is the appropriate authority. But as I
To
understand,
consider the representation.
yes, my lord, but they have not made party to the divisional engineer as a party respondent, not here.
Let the ninth, representation is before the ninth respondent.
They have also made before the divisional engineer. Page, my lord, 58.
Page
58.
58.
Yes.
This is in 2014.
All the application is on 2014.
No, this is in 2022. Page 69.
But the divisional engineer is the appropriate authority, my lord, that they have constructed. The secretary is, my lord, higher authority.
The secretary cannot deal with it.
I can deal with, but this is a higher authority, my lord. Divisional is the appropriate authority, my lord.
So let the secretary deal with it. If he's agreed,
Fine.
he can approach the divisional engineer. He has to be impleaded against served. Let the secretary consider, because they are not represented. That is the difficulty.
Yes.
Then he has to again make a fresh service.
Yes.
Yes. Within 2 months.
Thirty-five.
I beg to appear on behalf of the respondent number 15, man.
My lord, I am appearing on behalf of the respondent number 9, 10, 11, 13, 14 and 16.
State.
State, Mr. Mahato is appearing.
I do not find the state. Mr. Mahato is appearing in this one.
Mr. Lolil Mahato appearing on behalf.
It's not there.
Lordship, fact is that, Lordship.
Did you mention upon notice?
Lordship, that matter was already mentioned in the month of July. At the point of time I served the notice. In the month of July, matter was listed, but that was not taken up.
Mentioned yesterday.
No,
Day before yesterday.
Monday.
So did you put them on notice on Monday? No.
No. Lordship.
So that's why he's not there. He's always mentioned upon notice. It will be easier for you.
Loss.
You're wasting a day, isn't it?
Loss.
Affidavit of service. None appears for the state respondents. Paragraph, let the matter appear under the heading motion on 29th September.
Next Monday, in the winter, sir.
The court cannot accommodate you on next Monday. That is the difficulty.
Madam, matter to
29th
appear
September.
29th.
29th September. Paragraph, the petitioner is directed to serve notice upon the state respondents intimating the adjourned date.
Madam, kindly serve notice, private respondent.
You're already appearing. Why serve notice on you?
Again, you did mention update.
You are here.
But I am for the petition, 236.
Yes.
236, I am for the petition. My lord, grievance of the petitioner is that.
Service.
Yes, my lord, I have served, my lord. My lord, Mr. Dey is very aware about the matter.
Did you mention upon notice?
My lord, it is
No.
not.
So naturally cannot be taken up. Always
The
mention
land,
upon notice.
only consideration and representation.
In absence of the respondents,
The consideration or representation. my lord.
Mr. Dey, may I request you?
Page 18, the representation.
Consideration of what?
My lord, grievance of the petitioner is that petitioner is owner of the land. Land is utilized without compensation.
Land is utilized without compensation.
Without compensation, my lord. My lord, PWD authority. My lord, consider my lord, respondent of 3, special LA collector, North Chobbish Pargana. He is the proper authority, my lord.
Let me consider.
My lord, considered by the
Spec-
utilize the land.
Please hand over a copy of the writ petition, Mr. Dey, is without any document.
My lord, first, my lord, it is to be marketed how much land will be utilized.
I point.
So, my lord, that is the
Executive engineer.
executive engineer is the authority, my lord, to consider the.
So let
After
it-
that, he will file the, send the matter to.
So let the
prosecutor.
executive engineer consider the representation.
Yes, my lord. Within certain time.
Affidavit of service. None appears for the respondents despite service. Mr. Their appointment regular as colon, copy service the direction given. Paragraph, the petitioner's grievance, apostrophe, yes, petitioner's grievance is that the respondents have utilized his land for the purpose of construction of a Pakka road, but no compensation has been paid to him for the same. Stop. The petitioner submitted a representation in this regard before the concerned authority on 7th February 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the 4th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition, the petition is disposed of, directing the 4th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month.
Yes.
Yes, ma'am.
Within 1 month from the date of communication of this order.
Demarcation, other things is there, my lord, 2 months.
2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, in the event the petitioner is found entitled to compensation, such compensation be disbursed in favor of the petitioner within another month. Compensation.
Yes, my lord. No,
Within
my lord, he must send the proposal to the district authority. LA collector, my lord. He must ask for, send the proposal, then my lord, procedure.
the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Yes, my lord.
Get.
Disposed of it. Like this. Disposed. Who is appearing?
For initiation of proceeding under section 10, your lordship kindly sees, I have
Acted everything. 37.
I'm appearing for the private respondent. I'm appearing for the private respondent.
he is the person, who blocked my entire ingress and egress. I cannot even enter into my land. I have written to all concerned, all state respondent. Let there be a proceeding.
Why have you written
Starts
to all
from
the
page
respondents? Page?
It starts from page 36. Page 36 is addressed to the inspector in charge. Then page 39 is
Which is the representation to the assistant engineer?
junior engineer.
One would have been sufficient. One representation would have been sufficient.
Yes. For abundant precaution, I have written to everyone separately. Assistant engineer is page 57. And executive engineer is page 54. Page 54, your lordship kindly sees.
Let 57 be considered.
Yes, ma'am.
Because this is the authority.
Executive engineer and
Assistant engineer.
He
He is the authority to consider. You are the private respondent?
Yes, Lordship.
You will be heard by the authority?
Yes, Lordship.
The petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of PWD land adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation before the concerned authority on 11th April 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the state respondents that the fifth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of.
In the event anything is found, the authority.
That is automatic. That is automatic. They have to initiate. There is no other option.
Section 10.
That's an observation maybe.
To consider and dispose of the representation submitted by the petitioner dated such and such within 3 months that's why 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Disposed of which
Let there be only one
that
line.
is happening in all the cases.
Otherwise, we'll have to come once again in
You don't
another
have to
set
come.
of litigation.
In all the cases, the same thing is happening. They are initiating proceeding under section 10.
My lord, affidavit of service may be kept with the record.
I can show the affidavit of service.
My lord, before your lordship rises, my lord, may I make one humble request, my lord? My lord, item number 22 was called, my lord, I was on item 23. Now, my this great apprehension, my lord, will appear in the list tomorrow, my lord. Tomorrow, I'm in some difficulty, my lord. Anytime next week, if your lordship will keep it, my lord.
Item 23.
23, my lord.
23 not this week. Tomorrow is a holiday.
My day after, my lord, Friday, my lord. It's a long weekend, my lord. My lord, the petitioner had sought for time.
I just make it not this week.
I'm grateful.
Huh? Which is it?
Original side, item number 1 and 2. No, this is pertaining to the reassessment by the first tele collector. But they were supposed to file their notes.
So Ghosh.
Mr. Ghosh is actually debarred from your lordship to arguing further. So written notes of argument is here. I am handing it over for you. Perusal lordship. Nothing to argue, your lordship.
Further argument is.
There is no scope. We have already concluded. We have done it.
We have concluded.
Twice over.
Here is the written notes of argument.
Yes,
I've just have the copy, my lord. Only one thing, my lord. In the notes I come across in the last page, they have suddenly come up with this plea that, my lord.
Where is the written note?
This is my copy, my lord. Let them file it. Page 15.
Yes.
The last page.
Yes.
They suddenly now come up with this plea of the West Bengal Premises Requisition and Control Temporary Provision Act. This was never the case. Their own gazette notification is under Section 4 of the Land Acquisition Act of 1894. The award is in terms of Section 24 of the 2013 Act. The previous division bench has also observed the submissions of the Learned Advocate General that the notification is under Section 4 of the Land Acquisition Act. The judgment of Honorable Justice Sanjeev Banerjee records it. My lord, there is no scope for today changing their stand that the proceedings was under the.
My lord, this is my written notes of submission. I can clarify this because this is on previous occasion. Mr. Ghosh is actually trying to impress upon this point. This point is a legal point which is in the writ petition regarding the calculation of rent compensation earlier. In the writ petition, there is documents when first time the rent was fixed, that was basing upon this document. So this is not outside of the purview of that. And this is the for increasement or decreasement. Their case is that should be increased. Our case is that should be decreased. And my lord, with deepest humility, my lord, in the division bench, when the leave was given to us for actually proper course of action, we can go there. We filed this petition before your lordship. That is here heard out by your lordships in full length. Lordship knows that. Now we are actually filing this APA, that is the written notes of argument for your lordship's perusal. And the last point which my learned friend is now, but that is the document basing upon which the initial case was fixed. And their case is now they are actually saying that writ court is not a court of that other things are there in the written notes of submission. So that is, my lord, only one thing in the division bench, my lord, they went before this high court for actually the rent compensation is low. Now they are taking the point that that point is not taken. That is also in our minority note. So you lordships kindly judge.
Whatever my learned friend says is absolutely all right. So she'll kindly see page 60.
Now there is no scope. Mr. Ghosh is here.
No, I'm only on this.
Last occasion, Mr. Ghosh debarred.
Absolutely.
So
page 60.
My lord,
their award.
My lord, everything is before your lordship. So where is the scope for now?
Their award cannot. They have never argued this point. Your lordship will kindly recollect.
My lord,
yes,
have already
concluded.
Lordship, concluded.
Reserve for order, my lord. The award will, lordship will kindly see the pages are there, my lord. It's under the Land Acquisition Act. Never was it argued that it's under the
Written notes of argument. Written notes of argument submitted on behalf of the petitioner in the first of them. First number to them. Is taken on record. Paragraph. Arguments concluded. Judgment reserved. Tirupati.
I am grateful, my lord.
Great.
Sure. Number 2 te khali arguments concluded, judgment reserved. Second tate. দুটো আলাদা অর্ডার হবে। এটা লিখুন WPA 2289 of 2022 যেটা দিলাম আপনাকে। এই গ্যাপটা রাখুন না, WPA 2289 of WPO 2289 of 2022 আর WPO 2380 তে অর্ডার করুন, আর্গুমেন্টস কনক্লুডেড, জাজমেন্ট রিজার্ভড। Yes, appellate side.
Proceed forward.
Item 259, Group 7 motion.
I am appeal.
But before opening this brief, I should tender my apology for yesterday's incidents. This is not
It was not your fault or headache at all.
much of that. But the facts is that I'm a permanent permit holder. It's an interstate route from Baleshwar to Madhakhali, between state of West Bengal and state of Odisha. Now, for quite some time, the vehicle could not be operated due to some the mechanical defects were there. Now, the vehicle was kept with the ARTO or the RTO of the state, that state. Now, they wrote to the authority that the vehicle is there. And I also made a representation. That representation was not considered. Now, your lordship kindly come to the page, giving the page. Your lordship, then I moved before this honorable court, and my lord was pleased to pass an order. That is at page 31 of my writ petition.
Yes.
Your lordship will find that this vehicle could not be operated. Your lordship has been mentioned also. At page 32. This para starts from this para 2021, then requested the STO West Bengal to countersign the permit and so and so. The vehicle could not be plied from 1st April 2020 to 30th March 2022. Your lordship. Then, my lord, your lordship directed to consider the representations along with the documents by the taxing officer. Now, my lord, it has been communicated. Now, the taxing officer has given a hearing. That your lordship will find that at page 34, the notice of hearing to the petitioner, page 34.
Yes.
Now, the order passed on that is the next page, page 35, the order passed by the taxing officer. I need not travel, my lord. The last portion of the order, your lordship will find that the exemption has been given. That is there. Your lordship will find that relying upon the later, your lordship, this point 1, relying upon the later dated number so and so mentioned above, the vehicle number so and so will not be liable to pay the tax for the period from 1st April 2020 to 19th April 2021. The second point, and the vehicle on such and such will be liable to pay taxes from the date of granting counter signature, because this order was that consequential leave to be given by the, that is lordship's order, the counter signature by the STA West Bengal or any suitable date as may be fixed and by the Secretary State Transport. Now, the lordship, the very next page, the prayer made after this order of exemption, and this prayer made along with this order before the Secretary State Transport. That is the next page, page 36. That was made on 18th of July 2023. Well, you will find at the top.
Yes.
They received it. Now, another letter also issued by the Secretary State Transport Authority Odisha to the Secretary State, next page, page 37, to the Secretary State Transport Authority West Bengal for giving the counter signature, and it has been renewed. The permit, they renewed the permit, the counter signature has to be renewed. Well, that is the letter. Your lordship will find at page 37.
Yes.
Now, what happened, my lord? Well, during the course of this counter signature has not yet been given. That apart, my lord, the vehicle
is the route from your lordship will find at the later 30 later page 37. So later the route starts from Madhakhali to Balasur.
Yes.
Now this Madhakhali is in the part of the West Bengal. Now I don't know when this counter signature has to be given. The moment it has to be given, I have to start from Madhakhali. Now I bring the vehicle from the Odisha because Odisha there was the vehicle lying. Now I bring the vehicle Odisha and put it in the garage for some repairment. Now in the meantime, at that point of juncture, they say seize the vehicle. The authority that your lordship will find at page. That is first, your lordship, this page 41. A message come on the mobile of the petitioner, and a challan has been issued. Now the next page is the seizure. Page 42.
Yes.
Provision to park. Now your lordship finally come to the next page. A representation made to the taxing officers and the motor vehicle inspector, non-technical. The basis of the representation is that this calculation has to be made. Now, but this representation made on 8th of August 2023. Then read petition 5. During the pendency, just read petition I have mentioned earlier. A memo issued by a communication made to the petitioner by the ARTO. I prepared a supplementary affidavit. May I please copy? It amounts to a reply to this representation. Now your lordship will find it has been seen copy দিয়েছে এটা দিলো কবে আমাকে কোথায় ডেট নেই your lordship will find the next page of my supplementary P7. P7.
Yes.
Number the P7 page for page 5, your lordship will find 18/8/2023. At the bottom, the signature is given by the date, that's 18/8/2023. The next page. Page 5.
Yes.
Now, what happened, this is a calculation. Now, this calculation, your lordship will find this calculation actually has been forwarded by the additional regional transport officer.
Yes.
Who sent it, and it has been forwarded to him by the motor vehicles inspector to the ARTO. Namely, your lordship will find this has been not addressed to myself. It has been addressed to the ARTO. And the ARTO also, that is your lordship will find that next page, forwarded to the petitioner.
A copy has been given to you.
The copy. Now, whether the question lies here, the appeal provisions is there. Now, whether this is an order of the taxing officer or not. First. Second, if it is an order of taxing officer, this cannot be a order of the taxing officer. But in my respectful submissions, because second, lordship kindly come to section 11, then section 12 of the acts.
Of the
Additional tax act. The tax act. Section 11
of the Additional Tax Act.
Additional tax.
Okay. Yes, section 11 and 12.
But section 11 is the seizure.
Yes.
Now, section 12, notice of seizure.
Yes.
But section 12 is a notice of seizure. Now, these amounts, if it is their notice of seizure, then this has not been given by the ARTO. So, assuming the ARTO is a taxing officer, then this cannot be an order of the taxing officer. This is a communication in respect of a information which has been given by the motor vehicles inspector, non-technical, and your lordship will find that this is now your lordship will find at the bottom of that letter the motor vehicles inspector, non-technical.
Yes.
So this is the letter to the ARTO, and also the ARTO forwarded me this.
Yes.
So this cannot be a taxing officer's order. So your lordship, you will kindly come to the provisions of appeal. Any order passed by the taxing officer, then I have a right to prefer the appeal. Only the provisions is there.
Who is the taxing officer? in
But
this
taxing
case?
officer must be the ARTO or the RTO. Motor vehicles inspector cannot be a taxing officer. So for my Mr. Zebra is there also, he knows. The taxing officer and the order has to be passed by the taxing officer, and then I can only prefer the appeal against if I agree by that order. But that it is the last communication by the authority, and on the basis of this communication, even if I intend to prefer the appeal, I cannot prefer the appeal. First,
What is your prayer in the petition?
prayer is that but the period for which the given I am not on the quantum, I am not on every, but the period for which if they seize the vehicle, if I fail to pay the tax within a period of 30 days, but that has been, your lordship kindly see this even the order, assuming not admitting this an order, this has been sent to me on 18th afterward, but the signed on 18th of August. Now 30 days is the period after that the vehicle will be confiscated. Even if I intend to even if I intend to prefer the appeal.
Yes.
And today, the 6th September, no order has yet been passed by the taxing officer. Even if I prefer the appeal on the basis of this also, this is not a certified copy. So the memorandum of appeal, that has been incorporated in the notes that what has to be contained.
So
Section
you're
20.
primarily asking for the breakup of the.
Not only that, the vehicle be released, subject to the payment of on bank guarantee. Let me give a chance so that I can prefer the appeal, because no order of this taxing officer has yet been passed. Let the order of the taxing officer be passed so that I can get a chance before the appellate authority.
Let us hear the respondents, Mr. Debra.
And the whatever be the, I will furnish the bank guarantee. Let the vehicle be, because this is your lordship's last order that the moment they exempted, everything has been done. Only the counter signature part is there. Give them. Yes, that period. That I am not on that. That's the main thing. They have exempted. They have done everything. But in the meantime, if the counter signature hasn't come, this is the order also. Taxing officer.
And the vehicle was flying without the counter signature.
The order is also the tax to be paid. Your lordship, this last order of the taxing officer. What is the order? Your lordship, kindly come the order. That is at page. Taxing officer. Your lordship, kindly come to the order at page 35. Point number 2.
Yes.
And the vehicle so and so will be liable to pay taxes from the date of granting counter signature by the STA or any suitable date as may be fixed by the Secretary. But the Secretary STA West Bengal. So this is the order of the taxing officer.
Yes. So from the date of granting of counter signature or any other suitable date.
That any other suitable date, that has to be communicated by the.
Even prior to such communication, your vehicle was flying.
No, that, my lord, your lordship kindly
Since
appreciate kindly when the order passed. Namely, order passed, your lordship kindly see
11th July.
11 July. Now I have communicated the order for granting. The next page, your lordship will find that 18th July. This order passed, then I received this order, then I made the application before the STA. Now, then, my lord, the authority also sent a notice. then your lordship kindly come, then how can it be?
But did you wait for the counter signature? Did you wait for the counter signature?
Because certainly, my lord, where, my lord, the vehicle could not be operated because of the counter signature. As a whole, my lord, for a long period, they exempted. If it is the intention of the petitioner, my lord, I am ready to pay, my lord, the taxes even.
That is over.
That is
They are
that over.
exempted.
My lord, my lord, surface that the intention or the bona fideness that he had it been not a case that he would not have, he would apply, and they decided that no exemption should be given. Now, after the date, the counter signature has not yet been made by the authority, or any date suitable date, that tax can be payable. But that has to be communicated by the state. That is the order, my lord.
Your vehicle was intercepted when it was flying on the road.
No, that was standing. That was standing on the garage. They are there, not for a, it's a short period, but they are standing. I bought the vehicle from the Odisha, then I put, because these are lots, you kindly see this route is from Madhakhali to Balasore. Then I have to start from Madhakhali in West Bengal. Then certainly, but I have to bring the vehicle, my lord, here. Then I can start from Madhakhali. And my lord, it was standing, my lord, until and unless, my lord, lordship, I am agree to, my lord, even the bank guarantee to be furnished. Let me allow to not operate, because I cannot even operate, because unless the counter signature is there. Even today, assuming, not admitting, they have handed over the counter signature. At least from today, I can operate. Unless they grant me the counter signature, I cannot even operate the vehicle.
Let us see, Mr. Rim. Yes.
And my lord, I am ready to, my lord, furnish the bank guarantee. And let have a copy of the order of the taxing officer, so that even I am not on that, breakup or not, that is another part.
My lord's order.
And more so, my lord, in the seizure, it has not been mentioned. That is all very clear that the vehicle is standing, because there is no passenger at all in the vehicle. It is seizure, it has been. But that has been not specified. That is.
Yes.
আর কিছু বলার আছে? There is a twofold queries. First, my lord, STA decided is page pursuant to my lord's order. The STA letter, after hearing the taxing officer, PD letter, page 35. Page 35, serial number 1 and 2. 1, that is the exempted portion, bottom portion, my lord. 1, the second, my lord, and the vehicle number so and so will be liable to pay taxes from the date of granting counter signature by ST West Bengal, or any suitable date as may be fixed by the ST West Bengal. That has to be fixed by the ST West Bengal. His grievances, that has not been fixed. Next, that has to be fixed. Then, my lord, when vehicle is intercepted, wrongfully flying without counter signature, means, my lord, without permit, then question of seizure must be made. Then, my lord, interception seizure was made, and initially amount was detected 1,92,852. Then my landed friend client has paid for yes. Then, my lord, they have stated in supplementary affidavit, page 7.
Yes.
Page 7. My lord, vehicle was seized by the motor vehicles inspector, lordship kindly see. And ARTO or RTO, then sent to the ARTO or RTO, that is the, both are same power. Ultimately, my lord, it was ARTO wrote ARTO communicated the decision to him, to his client, that this is the amount you have to giving, calculation amount. You have to give, then, my lord, seizure is made. My lord, that is mean that there is two parts. One is till regarding counter signature, there is no assessment was made by this PBD. First point, that has to be. Then, my lord, illegally operating the vehicle, that is the, well, there is illegally operating the vehicle, lordship delivered number of judgment and also order, which has been preferred by my learned friend or another friend before the honorable division bench, my lord, that is affirmed the honorable division. This is the answer of the seizure. Seizure, my lord.
The petitioner says the vehicle was not plying when when it was seized.
That is looked into by the authority, appellate authority. That is not, the lordship has no power to do it.
Where is the order of the taxing officer which
This
is
is the
amenable
taxing
to appeal?
officer order. Taxing officer means ARTO or RTO. Lordship kindly see.
Which is the order?
This is the page 7.
Page 7 is an order by
Merely signed, motor vehicles inspector referred the taxing officer. That is, my lord, he calculate and sending to the taxing officer.
only the forwarding has been made by the ARTO.
ARTO?
Page, the next page, page 5.
My lord, my lord.
Only the forwarding is made by the ARTO, not the order.
Only for, because only initially, it is the practical aspect, my learned one also knows. The taxing officer only the sign the order. Because all the ministerial job done by the inspector.
Here the
concerned
taxing
inspector.
officer has not signed the order at all.
Yes, taxing officers only sign the, communicate the order.
On communicated an order passed by the motor vehicles inspector.
An order made by a taxing officer under this act may prefer an appeal.
But where is the order of the taxing officer?
That in that case, my lordship kindly say remand back to the taxing officer, ARTO contact, he will issue, my lord, necessary order. That will be better. And against that, he has to prepare an appeal.
To come with an explanation, a report. This should have been the order of the taxing officer.
This should have been an order.
Page 7 should have been an order of the taxing
My
officer.
lord, my lord.
So if your taxing officer can rectify this defect.
No, can they rectify or not, that is they are going to. That is their choice.
Because
rectify or not.
unless it is
That
in
is-
order of the taxing officer, the appeal will not lie.
So,
Net forum will dismiss the appeal on one line.
ARTO or RTO is a taxing officer.
Yes, here it is not. The order is not passed by the ARTO or RTO.
MBI calculate and
MBI cannot be the
calculate and send the. This is technical defect. Well, there is some technical.
So why don't you come back with a report curing this technical defect? The ARTO
Instead
has
of
to,
report, my lordship kindly set aside the same, directing the ARTO to issue fresh order. Otherwise, my lord, the time taken unnecessary, is delay and ultimately hold that he has to pay 1.5% of the, that is 1,92,000. He has to pay, as per division bench judgment, he has to pay 4 lakhs rupees. That is 16B hit, lordship, 16B hit, 30 days over.
yes, Mr. Mukherjee.
Only one aspect. If my learned friend's contention is accepted, then this order will go,
Yes.
this decision. Then they have no right to keep the vehicle in their custody.
No.
But this goes. Well, assuming this, if it is goes,
Calculation goes, but
not
not
the
seizure.
calculation. The
Seizure
seizure
has to be
itself.
there.
Then
Date of seizure is
assuming,
there.
yes, assuming the seizure is there. The seizure, then it
Then
has
in
to
that
be.
case, my lord, I have filed my.
I am not on that, my lord. I am only this
Kindly
aspect.
proceed.
I'm only
I
this aspect.
consult the matter, you have argue the matter, then
Things are there.
tell my lord.
My lord, if I
Caesar,
fail
date
to
of
pay,
Caesar is there.
whatever
Lordship,
be
all
the
things
amount,
are there
if I fail,
regarding calculation made by the MPI, আমাকে শেষ করতে দাও।
come to the part of that. But
তাহলে
if
কি
I
বল?
fail to pay by 30 days, whatever be the, else I have to prefer the appeal. Number eight, if a lordship set aside this, send it back to them. But the Caesar is there. My hands are tight in that event. I cannot. Even if I intend to prefer the appeal, that I cannot. And in that event, they will take steps to confiscate it, my vehicle.
Government lose revenue.
There should be a, if it is state.
The technical
Technical, I submit, I fairly submit.
That is right. But
That is
in
not a
that
date
event,
of Caesar,
30
that
days. Only to-
Caesar is charging.
in that event, these 30 days, by that
30
period.
days you get from the date of order of the taxing officer. 30 days of appeal is from the date of the taxing
Not
officer's
appeal,
order.
not appeal, not appeal. I am telling about to my lord, your lordship kindly come to the section 12.
Yes.
Section 12 of the confiscation of the additional tax. Five, no? Your lordship, section 12, your lordship will find,
The payment has to be made within 30 days.
yes, 5. In that event, my lord, I have to, otherwise they will confiscate. So, my lord, if it is even assuming the Caesar is there, then my lord, that protection should be given to me. And my lord, moreover, my lord, my client is ready to furnish a bank guarantee of such and such rupees. But this whole, now, my lord, even if I fail, but that, yes, but the bank guarantee
One
is
and a
of-
half. That is amounting to rupees, Lordship kindly see this section 16B. Lordship hold that and appeal
Yes, yes.
court also upheld their judgment.
yes, even if, assume,
16B. And with an undertaking, within 4 weeks, they will pay entire money. 16B, release of motor vehicles. No court shall release.
16B or 16B or
16B, 16B.
16B.
16B of the Motor Vehicles Act.
No tax act.
Yes, 16B.
No bank guarantee question, no, the bank guarantee does not.
Bank guarantee. Total tax.
1.5 times of the total tax due. You are agreeable to that?
And with an undertaking.
1.5 times? My lord.
With an undertaking.
My lord, I'm ready and willing to even undertake within a period of 4 weeks. That
They are ready to accept, go,
And
both the
also
God.
undertaking also given before the
in
authority.
terms of section 16B, they are ready to give an undertaking also.
Smart.
So the vehicle can be released on this ground?
Yes. An undertaking must be there. Because there is a judgment passed by the division bench also same like
that is in the act. My lord, I agree to undertake even. That is in the act itself.
Supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph. The petitioner is the owner of the vehicle bearing registration number OD hyphen
difficulty on this thing before passing the order, my lord. This is a, my lord, owner of the vehicles staying at outside the state of West Bengal. It is very difficult to, my lord, if they have given an undertaking, thereafter, my lord, they flew away, we cannot. So, so they must pay the entire amount. That is better. I shall take instruction. That will be better. Otherwise, my lord, that point, my lord, I just now learned.
They are ready to comply with 16B.
The difficulty is owner of the vehicle is outside. Then he must be a security for here, state of West Bengal. One security must be there. State of West Bengal. Otherwise, lordship can get very difficulty to collect the money.
Can be a surety for the state of West Bengal.
Everything may be
And where
complied
is
with.
the
Only
provision
thing,
for
my lord,
surety?
statute does not say so.
There
Moreover,
is the
my lord,
provision for a surety in the act. How can
Yes,
the court direct?
even if, my lord, he is a permit holder, and this permit, the countersigning authority
Is
is
West
his
Bengal.
client. No matter where I can go, I have to operate the vehicle the moment I get, even if,
Then
even if I,
cannot transfer or alienate.
my lord, that your lordship, that everything, even the vehicle and the permit, I will not have.
Can I
Yes,
get hold of it? That is the
You are
difficulty.
referring to provisions which are alien,
Yes,
to the,
yes,
which
correct,
are
yes, yes.
alien to the law itself.
I am not standing in that, my lord. That is
If you want to come back with short instructions, you can.
some instruction I have to come.
Because
the taxi-
submissions are being made from the state.
It is a technical matter.
I want to bring these on record.
my lord. In that even your lordship kindly appreciate one thing, that this period, my lord, that time I have shown you, lordship, that is 30 days. That will, my lord,
It is already over.
no. From the date you're assuming that is the order, my lord, 18th of August. Normally it will end on 17th of August. By 17th of September, then they will confiscate my vehicle.
And that is not.
No, seizure of date of seizure, 25th of July.
Where the 25th of July season? The provisions what? My lord, kindly see.
18th August is the date of assessment.
Date of assessment.
So that is my lord, section 12 says you have to assess and send the notice.
Date of seizure. 16C, lordship kindly see.
Now your lordship kindly see subsection 6 of section 12.
Tax Act.
If the owner fails to make payment of
My
the
lord,
aggregate amount under subsection 1 of the motor vehicles, the motor vehicles shall be sold in auction. Now, my lord, this is subsection section 12. Now, my lord,
Yes.
assuming this seizure is not section 12, section 11 is the seizure. Now, my lord, section 12 is a notice. That is not the seizure. Now, your lordship, that has been decided by earlier bench, my lord.
Lordship kindly see section
So, my lord,
16C.
assuming the
Subsection three.
notice, assuming the section 12 notice is the notice which has been forwarded to me even, that starts from 18th, my lord, according to the signature therein, 18th of August. And it will be ended on 17th of September.
Seizure made on 25th July 2023. On the basis of the seizure, lordship kindly see 16.3. Search and seizure. 16 subsection 3 of the Tax Act. Any officer not below the rank of motor vehicle inspector of the transport government of Wales or such other officers may be prescribed, may require the driver so and so, so and so, so and so, so and so, any other officer so and so. Next 3, notwithstanding anything.
Section
3. Content therein. Any officer
30
referred to
days
in
and
subsection.
15 days. Within 30 days, the dues have to be informed.
My lord.
Please come to 12, section 12.
Under section 12, the notice has to be given by 30 days. That is 12,
Yes, a notice has to be given by 30 days of the seizure.
from the date of seizure.
Yes.
Now, assuming the seizure has been made therein on
Sometime in July.
25th July. Now, then, assuming this is a notice under section 12, the second that has I have annexed with the
That is
supplementary.
16th August.
That is 18th August. Your Lordship, on the next page, the signature and the dates is there.
That is the assessment order.
Yes, thereafter, if I fail to pay, that is that from that date, the 30 days, if I fail to pay, that is subsection 6 of section 12. আমি বলছি assuming
Subsection 6 is on failure of payment. If the owner
subsection
fails, then the vehicle can be sold out.
the period is there. Your Lordship will find that period also.
16C.
Subsection 6 of section 12. If the owner fail to make payment of the aggregate amount under subsection 1, the motor vehicle shall be sold in auction by the concerned taxing officer. And a notice of specifying that is there. Your Lordship will find the 30 days, your Lordship will get in subsection. And that is there, Malat.
Here the auction will be after 30 days of issuance of notice.
Yes, Malat, the issuance of notice, assuming that is a notice, Malat, which I have annexed, then it has been, assuming it has been signed and even handed over to me. That is on 18th of August.
But this cannot be a notice.
Of a taxing.
No, subsequently section 16, subsection 3. Motor vehicles inspector sees the vehicle.
Of the Tax Act.
Tax Act, my lord.
Section 16.
16, subsection 3.
Section 6,
Yes.
subsection 3. What is this? Section 16, subsection 3.
Notwithstanding, refer to the main is detained any motor vehicle respect of which discharge until the person liable to pay the tax has satisfied the taxing officer having jurisdiction within 30 days. Person 30 days detention, taxing officer having jurisdiction to tax due to the penalty to be paid for non-payment of tax within the paid time. On the expiry period of 30 days, the vehicle seized and detained may, subject to provisions of the tax, be sold in auction unless the person liable to pay tax within the further period of 15 days paid to the taxing officer having jurisdiction liable.
Yes, my lord. But this is in all occasions, the section says taxing officer.
1 minute, Mr. Mukherjee, 1 minute. Well, section 16, 1. Any officer, state government not below the rank of maybe, what is a police officer not below the rank, so and so, any officer, motor vehicles inspector.
Yes, I am not on.
Of the transport government of West Bengal, of such other officer may be prescribed, may require the driver any motor vehicle to stop motor vehicles and close to remain stationary for the purpose of satisfying himself that tax has been duly paid or not so motor vehicles. Any officer referred may enter so and so.
The difficulty is the assessment is not made by the taxing officer. The statute says taxing officer
Always.
in all the sections.
But the Caesar may be.
Everyone can seize.
Yes,
The
Caesar may be,
assessment
but
of
that
the
that
taxing
also in
officer.
section
Then, my lord,
section 16.
this is that assessment can be made from the date of seizure. Otherwise, date of release cannot be made in view of the technical difficulty.
Assessment can be made from the date of seizure by the
taxing officer.
Where is that? It has not been made within 30 days of the date of seizure by the taxing officer.
And your lordship will
That is the
find
difficulty.
the representation also made to the your lordship will
And
find
since there is no seizure, no assessment by the taxing officer, the order also cannot be said to be amenable to appeal. The order of the taxing officer will be carried in appeal. This is technical.
Page 43, my representation. That before the taxing officer. After the Caesar.
What does it say?
This is representation where I have complained of that the vehicle has been seized. No calculation has yet been made. And I also prayed for a certified copy. You will also kindly
Calculation was made.
page 44.
But
I
instead
have
of-
asked for a certified copy
Instead
with
of
the order.
RTO,
I know, my lord, before that, my lord, I have to go the even
that
appeal.
put in
Then I have to
signature
offer
name
certified copy.
Calculation has already made,
I
but,
know.
but it is not signed by the,
If a calculation is made by a wrong authority, it is no calculation
that
at
is
all.
that is the main. yes,
So
sir.
we have to hold that there is no calculation of tax. Any person cannot just come and make a calculation and say this is the calculation. It has to be made by the prescribed authority. In this case, it has not been made. So it cannot be said that it is an assessment.
Then, well, I have to file one affidavit, so that will be better.
But the
Or to
vehicle has
decide
to be
the issue.
released.
Decide the issue whether this is.
And my lord, on this
Will
aspect,
it
because
serve your
he-
purpose if the representation is decided within maybe 2 weeks?
that representation, I think that has been replied to. Because thereafter they my lord sent. Your lordship kindly see my writ petition. I have annexed the date. Your lordship kindly see the date is 8/8 and they sent it on 18th. My lord, they signed it assuming that said 18th of August. So afterwards, so my lord, I think my lord, this is there, but I have asked for the calculation. They have given the calculation, but who has given the calculation? Not the taxing officer. I have asked for the certified copy of the order from the taxing officer. That has not been even replied to. My lord, your lordship kindly see, even if I intend to prefer an appeal, how can I prefer the appeal?
Cannot. Here it's about.
And nowhere, my lord, in the tax act
Your lordship
or the
kindly
additional tax act.
Give me some time, my lord, so that I can.
My lord, I also, my lord, I relied on a judgment delivered by my
That
lord.
is, that I will also rely some judgment, my lord.
That is a section on the section 12 of the additional tax act and the section 11 and 12. The judgment delivered, my lord, a long back, my lord, this is my reported 1997 volume 2 CLJ. My lord, your lordship, I hand over the.
I think let Mr. Devra come back with a.
There, whether these types of notice or communication at all can be treated as a notice under section 12 or not. That has been decided.
If it can be treated, if that is the.
Assuming, my lord, I'm
No,
submitting.
if Mr. Debra's client says that it can be treated, then you can prefer an appeal. It should come from the authority.
Yes. In that event, the certified copy is required, man.
Yes.
Well, the appeal, how can I?
Certified copy I have to give you. There's no problem.
Certified copy is what?
Even lordship can condone the certified copy. No certified required. You require entire file. That is division bench order. Entire file.
No, that can be done, but it should be an order of the.
RTO or ARTO. That is the main.
The taxing authority.
Look, this. No, I
Yes.
very much submit my lord. I'm ready to my lord furnish me lordship kindly. Think about the situation. If they grant
the amount, enter amount.
Since the petitioner is agreeable to 16B in its entirety, the petitioner wants to comply.
yes,
with
when
16B
that too by
completely.
undertaking by 4 weeks.
So
Lord,
let
even if
16
they grant my lord, the counter signature even in that, even I cannot even operate because the vehicle is in their custody.
Because that point is different. That is entire tax is due. It is for the some period. Entire tax has to be paid.
Counter
Up-
signature is one part.
One part, right?
The seizure and release
Seizure
is
is
another
our
part.
part. Now first seizure.
In any case, he
really-
has to obtain a counter signature in order to ply the vehicle in West Bengal, right?
That is different.
That is a different part.
Part.
We are not dealing with it at the moment.
But I am not on. I am not on that.
Let the petitioner comply with 16B in its entirety,
16B.
including the undertaking also,
My lord.
and let the vehicle be released.
Yes. Undertaking.
Then the petitioner can approach the authority for counter signature, whatever. Yes, let that be done.
Well, can I come back on next Monday or like that? I can talk with the secretary.
Mr.
But the
Devra is
revenue
little
matter-
apprehensive. I can make out. He is little apprehensive. He cannot decide what. Very well, come back.
Because my lord.
I will not stand on the my lord. I always
And let me just record yourself.
my lord, I have got the favor from my senior friends, my lord. I should not stand on the way. Let him take instruction.
just record
Let it be
yourself.
appear. Let it be appear.
The petitioner is primarily aggrieved Paragraph, supplementary affidavit submitted by the petitioner is taken on record. Paragraph, the petitioner is primarily, affidavit of service is primarily aggrieved by the calculation of penal amount made by the motor vehicles inspector within bracket non-technical bracket closed comma Kontai comma Purbo Medinipur, which was forwarded to the petitioner by the ARTO comma Kontai on 18th August 2023 on the ground that since the said assessment has not been made by the taxing officer, comma, the petitioner is not in a position to carry the said assessment in appeal. Under the provisions of Cholche. The West Bengal Motor Vehicles Tax Act 1979 and the West Bengal Additional Tax and One-Time Tax on Motor Vehicles Act, comma, 1989. Stop. The petitioner prays for release of his vehicle seized by the authority upon compliance with the provision laid down under section 16 capital B of the West Bengal Motor Vehicles Tax Act 1979. Paragraph. Section 16B of the Act of 1979 is reproduced below. Colon dash. Page 24. 16B. West Bengal 79 Actor. Learned counsel for the respondents seeks to take instructions. You want to come back with a report, Mr. Devra? Yes?
That is better.
Seeks to submit a report in the form of affidavit in this matter. Paragraph. Let the matter appear under the same heading on 18th.
What? Another thing, his challenge only concerning about the assessment is concerned. Calculation is concerned.
Yes,
Not Caesar. Not Caesar. Caesar made by the MBI. Correctly done. Only assessment part that has to be made by the ARTO or ARTO. That has not been done. That is why. That is a Caesar is correct.
I have recorded that.
Miles.
And
Only
pending that he can get back his vehicle upon compliance of 16B.
only one prayer, my lord. In the meantime, they should not take any coercive measure.
No. That is a.
We all.
I'll record.
No, Lordship cannot record this.
Not my lord, because the
Laborer's
vehicles.
responsibility from
That
the
is my responsibility.
Mine.
বলে বলবি আমি সেই রাত্রে ছেড়ে দেবো সঙ্গে সঙ্গে।
My lord. It's enough, my lord.
Sufficient, more than enough.
More than enough.
Next.
বললাম সঙ্গে সঙ্গে যত রাত্রে হোক 24 hours আমার খোলা থাকে ফোন।
60.
Lordship, Lordship, on the last occasion, Lordship has directed us to take instruction whether the permit has been renewed or not, Your Lordship. The permit, Your Lordship, the decision has been taken regarding the permit, and Lordship, but it has not been signed yet, Your Lordship.
What is the decision taken?
Lordship,
Positive or negative?
Lordship, no. Lordship, this writ petition can be dismissed, Your Lordship. Since the prayer in this writ petition has become infractious.
You are appearing for the petitioner?
Yes, my lord, I am praying for
Has become you are praying for?
time, my lord. One day time, my lord. Kindly make it not today.
That saves you. Come back with a report on the next day.
Lordship,
If it is renewed, then the petition becomes infructuous.
Yes, sir.
But I need a report in the form of an
Lordship,
affidavit.
that prayer was for counter signature by the state of West Bengal on the earlier permit, Your Lordship. The
Take a decision on 26th of August.
Yes, Your Lordship, the decision is taken, Your Lordship. The permit has been renewed, but it is not signed yet, Your Lord. The decision on the permit is taken,
So
Your
will you
Lordship.
come back with a report on the next occasion?
Lordship, as Your Lordship.
On prayer of the, I'm not recording anything today. Come back with your report.
Lordship.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 27th September. Should be
Obliged, Your
sufficient for you?
Lordship.
Okay. 61.
So I am for the writ petition. My lord, this is a writ application. My lord, we have challenged the allegation of overloading by the railways.
Yes.
Now, my lord, the act gives me the right to seek repayment under section 79 of the Indian Railways Act. Now, there are catena of judgments passed by this honorable court, my lord, by your lordships also, which I have annexed here, which entitles me to have the allegation reviewed once again. Now, my lord, on the basis of this allegation, my lord, I have preferred this writ application because they didn't answer to my representation. Now, my lord, petitioner is a leaseholder in respect of one parcel space, my lord, which at present he is operating under the railways. May I complete my submission, please? Now, my lord, petitioner lordship loaded one consignment on 19th of March at Okha at Gujarat. My lord, upon compliance of all requisite formalities, my lord, petitioner loaded consignment to the tune of 22.800 ton in a which has a carrying capacity of 23 tons. Now, my lord, there are circulars and there are notifications of the railways which says that railway receipts can only be issued upon correct payment of the consignments at the originating station. Now, my lord, will kind enough to take the exceptions to the report, though I have brought the manual with me. Lordship, will kindly come to
Give me a minute, please.
page 19 of my exception.
It's in the form of an affidavit?
Yes, my lord, it's a format of affidavit.
Didi? This is the exception. Exception. Only the railway has submitted a report.
Railways and legal metrology has submitted a report. So far as legal metrology's report is concerned, my lord.
You have not yet submitted.
My report is ready, copy has been. Kindly have a look.
I have not received copy.
My lord's order was there. If you kindly have a look.
Kindly.
Exception.
At the second page of my lord's order.
Yes.
Order learned counsel for the legal metrology submits, since proper functioning of the weighbridge in question is subject matter of several writ petitions. The report of the examination of such weighbridge be directed to be quoted before this court. Now, and then my lord order let this matter appear. Now, my lord, this is the my lord the report where my lord it has been annexed that the actual the inspection report that has already been done prior to it. Because once inspection is done, then the validity of the report is normally 1 year, unless otherwise something different is. My lord, suppose the functioning or something, my lord, you inform about non-functioning or not proper functioning. That is the report that in sometimes January, my lord, it was done in inspection.
We are in September.
We are in September, but the validity is 1 year.
Well, I should be grateful to my learned friend, my lord. He has at least highlighted some of the rules of the legal metrology, which will help me in substantiating my allegation against the railways. because I do not wish to make any exception against my learned friend's legal metrology's report, because this report speaks the truth. And Lordship will find from the exception of the report from the railways,
Although I have not.
there is a contrary stand.
Although I have not received the report submitted by.
The state.
Now I got it.
Now, my lord, may I place my case, my lord? Now, my lord, on the basis of element, now after loading the consignment at Okha and declaring the weight therein, my lord, it is the rules and regulations of the railways that at the originating station, that is Okha, where the goods were tendered to the railways for dispatching, the rule says, I have annexed at page 20 of my exception, that railway receipts, I was given a railway receipts.
Page 20.
Page 20 of my exception. আপনার এগেইনস্টে কিছুই বলিনি আমি, not a single line, not a single word even.
So you're not entitled to a copy.
No, I will definitely serve a copy. My lord, only I have a one copy. I'm seeing whether I. Sir, sorry.
Page 20, yes.
At page 20, my lord, railway receipts. Lordship has found B, left hand side B, top. Railway receipt, that is railway receipt foils of invoices, should not be granted till goods tendered for dispatch have been correctly examined and weighed. When senders are required to load their consignments, the railway receipts should not be given until the loading has been completed to the satisfaction of the railways. This is what the railway has to abide by at the originating station. Now, my lord, kindly be kind enough to turn to page 13. Why I am saying so, my lord, I will highlight thereafter, because railway are saying that they don't have any obligation to weigh the consignments at the originating station. That is the reason I'm highlighting these circulars, my lord. Page 13 of my exception. Lord, this is a circular of the railways, circular 7 of 2021. Clause 1, my lord. Clause 1.1, the originating station shall weigh at least 20% of the total leased parcel traffic loaded in SLR VPs on daily basis, in such a manner that the entire leased traffic originating from station is weighed in rotation. In case of leased traffic, if en route loading is permitted, this provision shall also be applicable on en route loading stations. Now, my lord, this is. Now, my lord, the allegation was this, that I have.
It's more clear.
Yes, my lord.
Page 20. This is
Page
a blank
20 is the manual, my lord. They have to follow it. Now, what has happened thereafter, my lord? When the consignment came to Shalimar, it was weighed behind my back. They didn't notify me. I have annexed a circular which says that they have to notify me if there is a surprise check. Now, my lord, they raised a punitive demand that your consignment is overloaded by 1.5 tons, so you have to pay the charges. I objected, my lord. I made a representation that I have a right of reverment under section 79. At least that has to be exercised in front of me to see whether the allegation of the railways are correct or not. I will pay all the charges for the reverment. Now, they didn't answer to that. Now, my lord, as the consignments were of electronic as cosmetic products, my lord, I have to take release of those goods upon making payment of the punitive demand on protest. Now, my lord, thereafter, my lord, I approached before this Honorable High Court, my lord, with a plea that already on this particular agreement, my lord, 2 overloading has been detected. 1, I didn't challenge. I accept. I didn't challenge. Second one is I have challenged here in this writ application. Because there is a provision in the Railway Board circular that in case there is a detection of more than 2 overloadings, there will be instantly terminated. They will be terminated. Now, my lord, Lordship has protected me at the very instance, my lord, directing the railways not to take any coercive measures. Now, I am protected to that extent, my lord. Now, Lordship, I will demonstrate that, Lordship, that In the Railway Board circular, my lord, there is a provision that they have to, if there is a surprise check, my lord, kindly come to page 13. One second, my lord, paragraph 1.2. This is very relevant.
30 of
Paragraph,
the
yes, exception.
Yes,
1.2 says, my lord has found, my lord.
not 30, it should be 20.
Page 13 of the exception.
13.
1.3.
1.2, yes.
Yes, 1.2 says, consignments loaded in indented parcel vans shall be weighed before loading. In case it is not possible to weigh the consignments at the loading station, the concerned CPS shall record the reason for the same in writing and also convey message to the destination station. Consignment once weighed shall not be weighed again, except as per the provision of paragraph 5. Now, Lordship, kindly come to page 50. I will take the provisions, Lordship, one by one.
15,
15, clause 2.4.
Yes.
My lord, if payment of parcel rake has been done at the originating station or at any intermediate station and is found to be overloaded beyond the tolerance limit, the entire excess weight would be offloaded at the point of detection. And the consignee leaseholder will have to take delivery of this part of consignment on as is varies basis.
Your page and my page is not telling.
At the point of
Yes, because 3:30 I have hearing matters to take. Page 15. Other matters released for the day, Didi. Other matter released for the day.
Yes. Yes, my lord. I read once again, my lord. If the payment of parcel van has been done at the originating station or at the intermediate station and is found to be overloaded beyond the tolerance limit, the entire excess weight would be offloaded at the point of detection, and the consignee leaseholder will have to take delivery of this part of consignment on as is varies basis at the point of detection of overloading. Railway shall not be responsible for any damage, deterioration, or loss to the excess of consignment duty offloading of the parcel vans. The entire cost of offloading shall be borne by the consignee or leaseholder. However, no punitive charges shall be levied if the customer carries out load adjustment at the originating point. Overloading of parcels beyond the permissible limit shall in no case be allowed to be carried in the vehicle. Lordship, last these two lines, overloading of parcels beyond the permissible limit shall in no case be allowed to be carried in the vehicle. My lord, if it is detected that I am carrying the consignments which is over and above the permissible limit,
Offloaded then and there.
then they have a responsibility to get it offloaded, because that, Lordship, has a cascading effect upon the railways. Anytime derailment can happen for my fault. So it is incumbent upon them that upon detection, either at the originating station or at the intermediate station, if overloading is detected, then they have to offload the excess weight immediately. And it is also incumbent that overloading of parcel vans beyond permissible limit shall in no case be allowed to be carried in the vehicle. Lordship, kindly mark these two lines. So the originating station has weighed it, granted me railway receipts. The railway receipts are there with me. I have annexed it. It is showing that what the weight I have put in the parcel space. Now, my lord, at what stage they have a right of surprise check? That is there at page 16, my lord. Kindly come to page 16 once again. Page 16. Surprise check, my lord. Notwithstanding anything contained in this circular, random surprise checks should be conducted by vigilance and commercial department's orders. For such check should be given by a vigilance officer in J grade and above, or by commercial officer in SA grade and above, in addition to DRMs. So they have a power of surprise check at the destination station. Lordship, I am not disputing that. Now, Lordship, kindly in the same page, kindly see paragraph 3, clause 3.2. What is my right under clause 3.2? Same page. In case of dispute regarding overloading detected as a result of surprise check, in respect of consignments of branded items, which are of standard sizes and uniform weight, with weight stenciled on the packets, such as dairy products, SM such as etc. The number of packages in the parcel once detected to be overload may be counted, and the average weight of the packet may be determined by weighing few packets on random basis in each different segments of consignments loaded at the destination point, in presence of the representatives of the consignor, consignee, and 2 gazetted railway officers, one from the commercial or operating departments, and the second from any of the department. Punitive charges already raised may be revised based on the payload determined in this manner, with the approval of senior DCM of the division and the destination point. So I have a right to be represented at the time of the surprise check. That right was taken away. Now, my lord, I am grateful to my learned friend appearing for the legal metrology. My lord, they have said a very important thing, my lord. My contention is this, my lord, I have not overloaded anything. It went through several checks at the originating station, in the intermediate station, and even if they conduct any surprise check, then I have to put on notice that your consignments will be reviewed by us once again. That notice was not given to me. Now, my lord, kindly see what the legal metrology has stated in their report.
Yes.
In their report, my lord, kindly come to legal metrology's report at page 3. This is one of the cause that has caused the overloading, my lord. Page 3 of legal metrology's report.
Page 3 of the report.
Legal metrology. Aman. I further say, Lordship has found, my lord?
Yes.
I further say that in any reading within the maximal permissible error can be treated as correct reading. The minimum operating speed and maximum operating speed of the automatic railway weighbridge are 1 kilometer and 15 kilometer per hour respectively as per the model approval certificate. My lord, this is, I am clarifying, the legal metrology has further clarified, which I have stated in one of the similar matter, my lord. Legal metrology has used an affidavit, which I have annexed here, saying that any weighment which being taken through the in-motion weighbridge, that has to be within the permissible speed limit of within 1 kilometer per hour to 10 kilometer per hour. If it is more than that, there will be error in the weighment report. My contention is this: the railways have not maintained the minimum speed which is required and which is stipulated in the legal metrology's report and also in the manual. From the manual also, I can demonstrate, my lord. Lordship, kindly come to legal metrology's report at page 24. This is an identical report which they have filed in another matter where they have clarified the speed related issue.
Page 24 of the
Of my exception.
Yes.
Page 24, my lord. Paragraph 4. I say, it is legal metrology's version, my lord. I say that the maximum permissible error of the automatic railway weighbridge will be such as specified in the 7th schedule, heading C, part 2, paragraph 2.2. Any reading within the maximal permissible error can be treated as correct reading. The minimum operating speed and maximum operating speed of the automatic railway weighbridge are 1 kilometer per hour and 15 kilometer per hour respectively, as per the model approval certificate. If the train does not pass on automatic railway weighbridge within the range of the operating speeds, the obtained readings may subject to error. So this is the contention. This is the contention of the legal metrology, my lord. Now, kindly see, lordship, what is the railway manual says also on the same issue. Page 21 of my exception.
The legal metrology in substance doesn't actually say anything.
It says that it has, because in the overloading,
They are on the principle.
they are on the principles. When the overloading allegation came, my lord, officers and representatives of the legal metrology was not present. So what the rule says, there is nobody to supervise the railway. My allegation is this: the actual train consists of a parcel van. There are some passenger bogies and SLRs of various natures. And the train went in 100 km/h over the automatic railway weighbridge, where, Lordship, the combined weight of all the SLRs and parcel wells were reported in the weighment sheets. And as I have countersigned the weighment sheet, the same was not made available to me because of the high speed the rail train passed through. The reading got incorrect. The reading went incorrect. That is one of the issue. And now, Lordship, kindly see page 21 of my exception, what the manual says. Exception of my lord. Same exception, page 21. 1429. 1429. Care and use of railway weighbridges.
Yes.
Care should be taken in using weighbridges to see that no vehicle is run on them while they are raised for weighment with the levers down. Vehicles for weighment are placed centrally. No engine is run on them. Vehicles are not passed over them at a speed exceeding 8 km/h. This is the, Lordship, this is the provision. Now, my Lordship, see kindly the railways exception. At railways report, my lord, page 6.
Give me a minute. Yes.
Yes, my lord, page 6 of the railways report. Railways report, page 6, paragraph 5. The demand for in-motion weight at a speed of 2 to 5 km/h is baseless, and there is no technical basis of such demand. Weighment of parcel van in in-motion weighbridge will remain same, whatever may be the speed. This is what happened with me, my lord. And they have not annexed any documents in the report, my lord will find, to substantiate that allegation. Weighment report has not been annexed. I say I have countersigned the weighment report, and I have seen at what speed the concerned train passed at that relevant time. That is the reason, despite this is reason, my lord, I should be obliged to my learned friend from the legal, because he has used the correct highlighted the provisions which is applicable to me and applicable to him at the same time. But he has said something different. And my learned friend is confident about the correctness of the weigh machine here. But in the report, he has said that the in-motion weighbridge at the originating station is defective. And nowhere in the report, he has said that what steps has been taken to get the in-motion weighbridge rectified.
Does it say that it is defective in the report?
Yes. Yes, my lord, page 3. Page 3, paragraph 4. Paragraph 4, my lord, with reference to statements made in paragraph 5 to 9A and 9B of the writ petitions are denied and dispute, it is stated that there is no system of weighing at Okha station as the weighbridge is not functioning due to defect in weighing machine, for which declaration of sender weights accepted policy has been adopted. This is the contention of the railways. Now they say that weighing machine at Poddopukur Shalimar is absolutely correct. They are very much confident about its correctness and fitness. But the same railway is saying that the weighing machine at Okha is not functioning. Now, my lord, under the manual, I have annexed what are the duties of the railway administration. It is clearly stated that railway officials have to intimate the legal metrology for periodical upkeep and maintenance of the weighing machine. And my learned friend is saying that it is remaining defective since, I don't know from what time.
That's not mentioned.
No documents have been annexed.
So, my lord, now it is 3:30, so I must invite your lordship's attention. First of all,
I have not completed.
No, you need not complete, because you first supply me the exceptions which you have used before the court and which you have served upon my learned friend, the meteorological department. I have a completely different copy.
No, no, if that is the case, I am supplying my copy.
Please find out.
No, no, he could have at least said to me before the hearing, I would have supplied a copy.
Right now, I find that it is different.
Oh, I don't know whether my learned friend had gone through this at this juncture or he didn't. Apni padhe nahi
Hey,
lage?
because I have compared with your paper, you are referring.
You compare. And this can be the defense, Mali. I have served him long back.
Not a defense. I have heard the matter. We'll
Now,
continue. on
he
some
could have
other
at least served me a notice that my copy is not telling or is illegible.
How could I know? How could I know? Because
I have
in the
provided.
meantime.
My lord, I have provided. I have served him on 25th of July.
whatever it is,
Other-
25th of July, I have
I
served.
should have an opportunity to compare it. Today, right now, I have compared it.
The copies are not matching. That is his
Oh.
grievance.
Because he is relying upon some pages.
Provide with the proper.
Then,
copy
Lordship,
in the
I will be
meantime
serving
and
today.
fix another day.
I will serving. I will be
Yes,
serving.
please do that.
Well, and let there be a date, my lord, because I have to consult regarding.
Because the petitioner has not completed as yet.
Yes, so that's why, my lord.
Has to be a date. Yes.
A date and
Interim order is there till 30th of September, my lord.
Railway
I am
is
not
not-
asking, Lordship.
Railway is
Fix
not
any
going-
date.
Railway is not going to take any coercive action.
Because you have given a wrong thing,
The
illegal thing.
That I will
It
place
cannot
before my
serve
lord.
because there's an interim order.
My lord, even if your lordship is not.
ঠিক আছে, আমি দেখেছি।
So, no coercive action will be taken up.
After vacation,
Yes.
Yes,
Uh,
my lord, then Lordship interim.
Railway is not going to take any action.
They have done an illegal thing.
That I shall place before my lord.
since it will take some time.
Because I have to take some instructions regarding meteorology department.
Yes, yes.
Because now my learned friend, he is really has exerted best effort to change up the track.
No, no, I have
Change
not
the
changed the
track
track,
and-
my.
Sir, the court will decide.
I have enclosed all the rules, all the regulations, whatever was it at my
Do
disposal.
not get agitated. I said the court will decide.
আমি আপনাকে ফ্রেশ কপি দিয়ে দিচ্ছি।
Report in the form of affidavit submitted on behalf of the fifth respondent is taken on record. Paragraph for learned counsel for the petitioner. Paragraph. Let the matter appear under the same heading for further consideration on. 17th November.
Lordship, interim order.
Reopening on 15th.
Interim order may extend.
Paragraph, the interim order granted earlier is extended till 30th November or until
Grateful.
further orders, whichever is served.
Grateful, man.
My lord, a copy of.
I am serving my undertaking, my lord. I am serving today.
I know he has nicely changed his track.
We'll find out who has changed.
I have everything. I have these there on records.
ঠিক আছে দিন তারপরে দেখছি।
Yes, next.
Grateful, ma'am.
Hearing matters. Hearing. One hearing হবে তো। Other matters group 7 release করেছি। One release করবো।
I am for the respondent, Your Honor.
But I appear for the petitioner.
I am filing the
Affidavits
affidavit
of
in
opposition?
opposition. Yes, yes.
Yes, yes. The last occasion I filed my reply,
Reply?
the opposition was not on record.
Actually, I missed the list.
Yes, so are we ready for the hearing?
Yes, yes.
Yes.
Well, what has happened, this writ petition,
Take the microphone, please.
My lord, in this writ petition, I have challenged an order refusing my mutation. I've applied to Bharati, my lord. There was a earlier writ petition wherein there was an order directing the respondents to consider my application for mutation for within 10 weeks. There was a time period within which they were supposed to give me a personal hearing and dispose of. That they didn't do. We had to file a contempt petition. Pursuant to the contempt petition, a hearing was given and my application was refused. Challenging that, we have come up before my lord. So I just give a short brief what has happened, my lord. In this matter, my predecessor in interest was granted a lease on 24th of September 1951 by way of a registered lease of deed. Now, subsequent to that, my lord, the predecessor in interest expired, leaving a will. Now, after that, sometime in 1988, the legal years of my predecessor in interest, they wrote a letter to Bharati asking them to mutate the name of my husband, which was done by Bharati. Now that after that, the property was mutated in the name of my husband. Later on, my lord, my husband, by the name of Priyabrata Ghosh, he expired in 2005, leaving behind a will, and by that will, he bequeathed the property in my name. Now the will was probated, and then in 2006, I applied for mutation, and I have paid the lease rent till March 2020, which was accepted by Bharati. Now, after I have applied for mutation, there was no response. Now, we had written in numerous letters, given reminders to dispose of my application. When there was no response, I was constrained to file a writ petition, which I told my lord. And since there was no order, they did not appear, my lord, and there was a direction for them to dispose of. Nothing done. Contempt, refused. After the contempt, given an hearing, refused. Now we are before my lord. Now this is the backdrop. My lord, will kindly see my.
Cancel the reason that meeting.
My lord, they have refused to entertain my application for mutation.
What is this
May I come to the application?
the order dated 22nd July that that is impugned in the writ petition?
That's annexure P10, my lord. That is the order of
Refusing
Bharati.
your mutation.
Yes, my lord. It's P10, annexure P10. I'm led by Mr. My lord, wait, kindly come to page 62.
Yes.
My lord will. This is the my lord will kindly come to the reasoning. The next page, the middle of that page, my lord, page 63. Now, on examination of all the documents submitted by Srimati Geeta Ghosh and also the records available in the university's file, my findings are as follows. The original lessee, late Gyan Chandra Ghosh, passed away on 21st of January 1959, leaving behind 6 legal years heiress. On 30th of March 1988, all the legal heirs and heiresses gave no objection to recording the name of Priyabrata Ghosh as the lessee for the unexpired period of lease. On 1st of January 1995, the registrar Bharati informed Priyabrata Ghosh, son of late Gyan Chandra Ghosh, that the leasehold interest had been mutated in his favor on the strength of the no objection submitted by other heirs of the original lessee, late Gyan Chandra Ghosh. On 24th of December 1993, 4 legal heirs of late Gyan Chandra Ghosh executed a power of attorney in favor of late Priyabrata Ghosh for sale, assignment, gift of the leased property. Priyabrata Ghosh, son of late Gyan Chandra Ghosh, passed away on 22nd of November 2005. Srimati Geeta Ghosh, wife of late Priyabrata Ghosh, submitted an application for mutation on 25th of September 2006 on the strength of a will dated 5th of April 2008, probated before the Calcutta High Court and also on the strength of a registered deed of release dated 14th of July 2006. There is no doubt that the university recognized and recorded the name of late Priyabrata Ghosh as the lessee, as the nominee of the years of the unexpired period of the term of the lease. However, the legal heirs of late Gyan Chandra Ghosh did not give any authority on such and such or any other date to late Priyabrata Ghosh to transfer or assign the leasehold right to any other person, nor did they indicate that the heirs of the late Priyabrata Ghosh would be entitled to inherit the lease in exclusion of other legal heirs of late Gyan Chandra Ghosh, the original lessee. Moreover, late Priyabrata Ghosh did not take consent in writing of the university before assigning the benefit of the lease to Srimati Gita Ghosh, his wife, which was required as per the original lease deed. Therefore, the will dated 5th of February 2005 and the probate dated 19th of April 2006 violate the conditions of the original lease deed dated 24th of September 1951, and Vishwabharati is not in a position to recognize Srimati Gita Ghosh as the lessee for the unexpired period of the term of the lease. So this was the order. So, my lord, we have challenged this order and we have filed this writ petition, my lord.
And my first bone of challenge, bone of contention is that, my lord, your lordship must have seen the order. It says I'm not a lessee. My lord, High Court sent it back to find out whether it should be mutated in my name or not. After finding that I have a lease, they go back one step further and say that I'm not a lessee.
Was the earlier order in your favor or favor of the husband?
Well, in my favor. But kindly see the order, will it? 62. But kindly take page 60, my lord.
60?
60, my lord.
Yes.
My lord, I was the petitioner, as in the lady was the petitioner, my lord. And takes the last paragraph, my lord. Dispose of the application petitioner for mutation in accordance with law within a period of 10 weeks. Now, my lord, kindly appreciates what has happened.
Court doesn't hold her to be a lessee. The court only records her submission.
Yes, my lord.
The
My
court
lord,
doesn't
no.
say that she is the lessee.
My lord, it is, my lord, kindly say, petitioner's complaint, she being the successor interest of the original lessee has inherited a plot of land.
Petitioner is complaining. That is the statement. The
Yes, my lord. My lord, today I must humbly what I'm on, my lord. My lord, when they're looking into mutation, my lord, mutation does not give any right of title in any manner. Your lordship knows it. Your lordship is hearing it every day, my lord. Whether at the time of, my lord, seeing whether it can be mutated in my name, whether the occupancy is the main thing or my title. Most important. Now, my lord, when I file this writ petition, the only point which they take in their opposition is that the lease was only given to Gyan Chandra Ghosh and not to his assigns or legal representatives. The only point, my lord, your lordship sees. Other than that, everything has been admitted. Kindly see that affidavit in opposition.
The order rejecting your prayer goes a little further than that.
Yes, but my lord, today we are before here, your lordship, my lord. When I say that
Primarily for a no objection from the other legal heirs of the original lessee.
my lord, today kindly appreciates, my lord. The lease has been granted in my favor by the probate. No one has come up and challenged it. My lord, what would be the effect? Let us understand, my lord. Let us say there are others also. Let us say, my lord, I'm taking my worst case, that I am not the only person who would have been entitled to the lease. But I am someone who's entitled to the lease. Now, if someone challenges it, my lord, that would not oust me as a person who's entitled to pay tax. Now, they are trying to draw into, my lord, the only thing which they have to see, my lord, is whether I'm entitled to a lease or not in my own name or with others. My right will accrue. There will be other persons who will be also have their names mutated in that records. But that will not take me off from my right as a lessee. That is what they are not holding. They are saying, how could you be the only lessee? Well, kindly see the order once more.
Say that the husband did not have the right to transfer.
Well, that your lordship will kindly see, my lord, there was no requirement. Because the lease deed, my lord, because this is what that is what I'm on, my lord. By trying to appreciate my right as to get it mutated, they are trying to do away with my lease. That was not the scope.
You annexed the lease deeds?
Yes, yes. That is not the scope of the earlier order or my learned friends, officers' domain. He couldn't have or she couldn't have gone into the respect of whether my lease is there, lease is correct or not. Yes, if she could have or he could have come to a conclusion that I'm not a lessee. Because my lord, kindly appreciate whether the lease deed is there. My lord, kindly see the lease deed once, my lord. It's at page 24 of my petition, my lord.
Yes.
This is the lease.
This is the original lease.
Yes. Of Gyan Chandra Ghosh. Now let us see the order, my lord. What does it say? It kindly comes to 63, my lord.
Yes.
No dispute about Gyan Chandra. My lord, kindly take straight on, my lord, what?
No dispute till Priyobroto.
Gyan Chandra first. Let us start with Gyan Chandra, the original lessee. No dispute about that. Then all the legalizers and heiresses gave no objection to recording of the name of Priyobroto Ghosh as the lessee for the unexpired period of the lease. So Priyobroto is fine. On 1st January 95, registered officially informed Priyobroto, leasehold interest has been muted in his favor on the strength of no objections and by other heirs or heirs of late Gyan Chandra Ghosh. On 24th December, 4 legal heirs of Gyan Chandra executed a power of attorney in favor of Priyobroto for sale, assignment, or lease of the lease property. Now, my lord, here is where I join the issue. Is this required to be looked into? That is what I'm on, my lord. For mutation, my lord, once you find that the lease was granted, for mutation purpose, my lord, this cannot be looked into. Yes, my lord, if I'm going to transfer the lease is bad, that is a separate authority which will look into it. That is what I'm on, my lord, only. Then, my lord, sees Priyobroto passed away. Geeta, wife of late Priyobroto, submitted application on the strength of a will dated 5th April, probated on 19th April before the Calcutta for the court, and also on the strength of registered deed of release dated 14th July 2006. There is no doubt that the university recognized and recorded the name of late Priyobroto as the lessee, as a nominee of the heirs for the unexpired period of the term of the lease. However, the legal heirs of late Gyan did not give authority to late Priyobroto to transfer or assign the leasehold right to any other person. But this is a clear case of, my lord, life interest and complete interest. But once it is held that the lease was granted to Priyobroto without any contingency, it doesn't come to that there was a contingency, it was a life interest. Once it is given, but can this be held? Kindly see, my lord, H.
Yes, yes.
This cannot be held. And that is the ground on which he or she holds, or the authority holds, that no, this lease couldn't have been transferred.
Was there a requirement of consent from the university prior to
that they are saying they had given? The only thing which they are saying, my lord, kindly is H. That it was given, consent was given, but the consent was not given for transferring further. Because, my lord, lease, if it is once given, my lord, lease cannot, if it's contingent, then he has to come to a conclusion that the lease to Priyobroto was contingent. Kindly comes to the earlier paragraph, my lord. See, my lord, on 1st January 95, the leasehold interest has been muted. Man, I'm not reading those, my lord. The leasehold interest has been mutated in his favor on the strength of no objections submitted by other heirs. So what is being transferred? The lease has been transferred. Once, my lord, it's more like a gift, my lord. Once that has been given effect to, can there be any further contingency? I'm asking myself. Kindly reconcile C with H, my lord. That is why I said this needs to be reconsidered. This is a conceptually, my lord, on a legal platform. Your lordship kindly appreciates what I'm trying to say, my lord. If the lease has been granted and you say lease has been granted on no objection, can you again go back and say, look, your lease is contingent on the no objections? That is the only point, my lord. And my lord, this point ought not to be looked into because there's a malafide behind this. The attempt is, my lord, the attempt is to delease the entire thing, if I may say this.
And let us hear the.
Well, this is. Huh? Oh, and my lord, the lease rent has been paid.
Lease rent has been.
Yes.
They're accepting.
Yes, yes. Well, that even the opposition, my lord, kindly, they have not disputed that. My lord, the main contention, paragraph 6, opposition that the lease is not subsisting. That is the attempt, my lord. Page 3, paragraph 6. I specifically deny that the lease is still subsisting. Just after the numbers of the paragraphs.
Expired.
Sorry, madam?
The lease period has expired.
No, it's 99 years from, my lord.
99 years.
Yes. From 1951. My lord, why are they saying that? Because they are finding, my lord, that that is on contingency.
Well, let us hear the
Well,
university. Yes.
My lord, may I take your lordship's kindly, my mind? Yes. And my lord, I hope my learned friend restricts herself to the opposition, my lord. And my lord will kindly have a look at the opposition as to what she has denied.
He will decide everything
No, I'm not deciding.
because
my
he's
lord.
a petitioner.
No, my lord, that is the law. That is the law. Your lordship knows better than me.
Yes.
Well, back to the case 24 September 1951. 24 September 1951, a deed of lease was executed in between Gyanchandra Ghosh and Vishwabharati University. Several terms and conditions are there. Even it has specifically mentioned if someone violate any terms and condition, lease will be determined. That is there. I will place the deed of lease. Gyanchandra Ghosh died 21st January 1959, leaving behind widow, 2 daughters, 3 sons.
Yes.
30th March 1988, after 30 years, almost 30 years, Gyanchandra applied for,
The legal has applied for.
applied for mutation. Gyanchandra died 21st January 1959, and kindly come to the page 30. No, and kindly come to the page 38.
Of the petition?
No, this is the petition, page 38.
Yes.
Yes, solved haphazardly. There is no serial.
You have acceded to this.
Yes, kindly, may I read the paragraph, second paragraph. শান্তিনিকেতন সোয়াংশ পূর্বপল্লীস্থিত বিশ্বভারতীর সোয়াংশ নামে থাকায় তার উক্ত অত্র সোয়াংশ জ্যেষ্ঠ পুত্র ও অপর স্বাক্ষরগণের ভাতা শ্রী প্রিয়ব্রত জ্যেষ্ঠের নামে নামপত্তন করিয়া দিতে বাধিত হইব। All of the signatories are the heirs of the Gyanchandra Ghosh. Kindly appreciate if they are only consented on Priyabrata. If the name mutated in the name of Priyabrata, then they don't have any objection. Specific. And kindly come to the page 38A, not properly staged. This page in that there is a not properly staged. Kindly come to the page 38A, second paragraph. May I read? Will be grateful if plot number so and so situated so and so, which is the name of the aforesaid late Gyanchandra Ghosh, is mutated in the name of Priyabrata Ghosh, only in the name of Priyabrata Ghosh, who is the eldest son and number one signatory of the, and other brothers and rest of the signatories. The signatories, this is important. The signatories have no objection if aforesaid plot so and so mutated in favor of the Priyabrata. There is no whisper as regard to the upon the death of his heirs will come into the picture, then we don't have any objection, nothing is there.
That was not, that did not arise, that situation did not arise at that
Yes,
time, madam.
yes, then I am on that. The only in the name of Priyabrata Ghosh, only Priyabrata Ghosh. Yes. Kindly. Therefore, my first point is that when they have applied after death of Priyabrata, when his wife applied for mutation, the objection, no objection is required of other years of the Gyanchandra Ghosh.
Madam. The others have given full power to Priyabrata. So
Nothing, only for the purpose of mutation. Only for the purpose of mutation, what is there? But what they have done before the death, Priyabrata published his made his last will in the favor of his wife. But kindly appreciate, they have took the probate. Probate has been granted in favor of that wife. But originally the Vishwavarati is the leisure. The Priyabrata was the lazy. That granting of the probate, the lesser is not binding upon by the Raja of the probate. And they don't have any knowledge about the grant of the probate.
notice was served.
Please.
During the personal hearing, everything was submitted.
No, this is the after granting the probate personal hearing. Don't mislead the court. Please sit. Please, no. I am arguing. I never disturb when they are arguing.
Give me a minute. Was the notice of probate served to the?
No.
Do you have
No.
the notice here?
There is no provision for serving notice in the lesser. There is no provision in the Succession Act.
I'm talking about the lesser, I'm talking about the other ministries.
Everything was, notice was served. So far as Vishwavarati is concerned, is when the personal hearing was given, they sought for copies of everything we have produced before them, then the personal hearing was given.
Sought for prudence of the probate order, the post-probate, not pre-probate. We are not binding upon by this order.
That
The time is the essence.
granted in their absence.
Yes.
In their absence.
Yes.
She has not taken that point. It's
What
nothing-
point? It's a law point of law.
Yes, but where is?
It's a point of law. I can take any point of time, even go before the ethics code also. It's a point of law, cannot take, should not write in the opposition. It's a point of law. I am not talking about the fact. This is the writ court, not a fact-finding court. I am talking about the law. And my point is that the Vishwavarati is not binding upon by the probate court order. This is point of law. I am not bound to write to the law in the position.
Yes, what is your next submission?
Next, the third point. Yes. Milord, they have covered, the Priyabrata was covered. After mutation, his name was covered by the clause 10 and clause 11B. I want to place the clause 10 and clause 11B of the deed of lease. And before placing that deed of lease, I want to place the page 60. The learned fellow has very carefully misled this honorable court.
Yes.
Page 60.
Of the
Very interesting. May I read that
Of
last? Yes, last paragraph. This is audio. Writ petition number so and so is disposed of by directing the registered Vishwavarati. Page 60.
Yes.
The writ petition choice is disposed of by directing the registered Vishwavarati, the respondent number 2 herein, to dispose of the application of petitioner for mutation dated so and so in accordance with law. In accordance with law, this court never decided that kindly treat him as a lessee in accordance with the law. But he has submitted that, no, this honorable court has already held that the Gita Ghosh is the lessee. Please consider our application in accordance with the law. If law is not permitting, my lord, my hands are tied. Yes, I am placing the list, deed of lease. Kindly see the clause 10 of the deed of lease. My hands are tied. They have violated the terms. And they are very clever. They have purposely not pressed the clause 10. Page 32. They should have filed a typed copy. I don't know, my lord, how this copy allowed at the time of filing. It's very.
Use the opposition, I don't know, my lord, what is the. Not
This is their documents. No need to.
the paper.
Yes,
they
just.
Just used an opposition. How
She
could
is referring to your lease deed.
This is documents. It's totally. I'm not making any story. This is a annexure, your annexure.
Yes, paragraph 10.
Clause 10, page 32.
Yes.
May I read, my lord? That the lessee will not, without the consent in writing, the lesser concerning writing of the lesser, first had and often assign, transfer, late, or mortgage the benefit of the lease hereby granted to any person, provided that such consent will not be withheld in case of transfer, assignment of mortgage in favor of the person who are live member of the Vishwabharati. And kindly come to the clause 11B. My lord, he made the last will published, granted without knowledge of the Vishwabharati and without consent. Without consent. This is the, and deed of lease is the sacrosanct. And kindly come to the clause 11B. In any of the following clause or events, the terms hereby created shall forthwith determine and it shall be lawful for the lessor at any time thereafter into and upon the demise premises or any part thereof. And kindly come the after 3 lines. Any incident, breach of any of the covenants on the part of the lessee, herein content is right of re-entry and the lease will be, right is determined. The determination clause is there. My contention is that he has assigned the property to his wife without consent of the Vishwabharati, and the violation clause is there. Therefore, they are covered by the clause 11B. They have violated. So my hands are tied. We are the authority of the, our duty to safeguard the properties of the Gurudev. We are the authority. What they are saying, my lord, and kindly appreciate, my lord, when they have made the application by the petitioner, that is the reason, my lord, others' consents are required. And what is the clause? Only the elder member can be allowed as a lessee. That clause is there. Kindly see the clause 4. Wife is not the elder member of the lessee. Clause 4. Clause 4. That the lessee shall not, without the previous sanction in writing, leisure, erect or build so and so demise premises other than the building as well, not without such information. And I mean, and members, can you allow me 2 minutes, minute? This specific clause, only the elder member will be allowed as a lessee. The Gita Ghosh is not the elder member of that. That clause is there, my lord, I can show you. I think that it is a case. That clause is there, my lord. After demise, my lord. Yes. My lord, kindly come to the page 34. Kindly come to the page 34, the last paragraph or paragraph 6. If the lessee breaks or violate any of the covenants herein contained, C, in the event of the sooner determination of lease by the reason of lessee ceasing to be a life member of the Vishwabharati on the death of lessee who is died without having made a transfer or bequest valid according to this present, and whose heirs or the nominee whose heirs does not become the life member Vishwabharati, the lessee, this not all are not applicable. Lessee, the heirs and heirs of the deceased lessee, the case will be entitled within. So, my lord, determination, the sooner determination clause is there. So they are shouting that lease is not continuing. No. If anyone violate, we can determine the lease as soon as possible.
Determined? Where is the document of termination of the lease?
That is the reason, my lord, we have not renewed.
Where is the document? You have to terminate by executing a document?
Then I have to ask them, my lord, whether yes, my lord, I will.
Terminate a lease, you have to execute a document to that effect.
Yes, my lord, I will. Right now, I don't have any instruction, my lord. If you will receive one, I can ask them and I can produce the document. Because any violation, we can determine the lease. Sooner determination clause is there.
Has been annexed to the opposition.
This is, I am reading on your document.
No, nothing has been annexed to the opposition. No determination done, madam. If she is relying on a particular clause, she doesn't know whether the.
And
determination
madam,
has
please consider another aspect. Not only the mutation was granted, leasehold right was transferred in favor of the husband, the petitioner.
But by not
Not by will, by your authority, by the university. The leasehold right was transferred.
Transferred to whom? To Kuyapoto. He died after the day. That is not surviving.
The leasehold right, not the mutation. There is difference between the two.
Leasehold right allowed to the Priyabrato. He died. After the death of Priyabrato, what is the fate of that? So there is not existing that transfer. The transfer is always the inter vivos. When the Priyabrato died, after the death, that is not exist.
Has made a settlement before death. Only thing is whether permission was taken. There is a clause for taking permission.
Kindly see the clause. This is the clause, your lordship, where the transfer has to be done in a third party.
No, we have not done.
Sir, madam.
Case of a bequest also.
Lordship kindly sees.
Please come to page 30.
Clause 10.
বোঝাই যাচ্ছে না বড়
পড়ে দিচ্ছি তুমি শুনুন that the lessee will not without the consent in writing of the lessor first had and obtained assigns, transfer, let or mortgage the benefit of the lease thereby granted to any person provided that such consent will not withheld in case of a transfer, assignment or a mortgage in favor of the person who are life members of Vishwabharati.
So number one, the wife is not a life member.
Is not a life member.
Yes. And secondly, this is a transfer to any person, not an outsider.
But your lordship kindly sees the language
Nowhere has
without
it
the
been
consent
stated
in
that
writing.
if it is within the family, like
Yes.
in case of like solid property and other properties, we have always found a a specific covenant in the deed that if it is transferred within the family or within close relations, no permission is required. But here there is no such.
Yes,
covenant.
that is not there.
Sir,
Either,
Madam, the court is speaking.
Yes, I am sorry.
Lordship, either your
very
lordship, it can be by way of a succession or by your lordship, by a testamentary disposition.
Anything, yes, but I think a previous consent was required.
Lordship, in this
I can,
clause 10,
I can send this for reconsideration, but that will really not help you, I feel.
There
are
if your
certain-
lordship again send it back, the same answer will
Same
come.
answer will come.
Yes,
So it has to be decided.
it has to be decided. It is required to be
These are
decided.
certain issues which need to be
Yes, my lord.
considered.
I'll because Mr. Sini, Mr.
Yes.
Ray, your lordship was there, I will inform.
Please do that because
please.
I'll fix another date
Lordship.
because clause 10 is in.
We will
for
show your
transfer
lordship,
of-
the authorities, your lordship, which will clearly show that this particular clauses, your lordship, is basically your lordship for your lordship. The outside, the reason is your lordship. If there is no your lordship testamentary disposition, there has to be your lordship that it will devolve upon the heirs. Now, what has happened? Your lordship, the Pio Broto, he made and executed a will. Now, by way of executing a will, your lordship, can it be considered as a transfer to a third party? He has executed a will, and on the basis of the will, the Honorable High Court at Calcutta, your lordship, has granted a probate. That exactly has happened.
Language is assign, transfer, let, or mortgage, not
That's
only
may,
transfer. This
lordship,
is an assignment?
yes, yes. No, this is not an assignment. This may be a mode of transfer.
Yes, it is.
It's a mode of transfer. Just like a
So
gift,
please come
sale
back.
deed.
Please come back.
Yes, your lordship. I will satisfy.
You have heard the submissions made
Yes,
by
yes,
the
yes.
council.
Lordship.
So you need to respond to these
Yes,
submissions.
yes. Only,
My lord
only
can-
this aspect I'll
My
satisfy.
lord can,
There is
my
no
lord can do
termination.
one thing, my lord. My lord can frame the issue and send it to
No,
that
this is not
point. No, frame the point and
Will not go
send
back,
to
your
the
lordship.
Vishwavarati for reconsideration.
Lordship, this is the approach. Your lordship, termination clause she is reading. There is no termination at all.
To decide.
And moreover, mutation.
Come back.
And moreover, your lordship, with deepest will come back and Mr. J will certainly will come. Mutation, lordship does not actually decide the title. It only your lordship right to be given to that person to pay the property tax. So today, if they want to terminate, they have to take steps. And that exactly they have not taken.
Council says that it has been terminated, so I would like to see the documents.
Lordship, kindly record a submission then.
Yes.
No. Kindly record a
Says it is
submission.
terminated, the lease.
My lord, I am not aware, my lord.
Yes.
I am not aware of that.
Then don't say so then.
Don't say so. আমি বলে দেবো যে আমি জানি। কি বোকার
No,
মতো কথা বলছো?
you have said that it has
Not
been
aware.
terminated.
I am not aware. Should I mislead like you
You
or your
have made-
senior?
Do not make irrelevant submissions, madam. This is a court of law.
মিথ্যে কথা বলতে বলছো।
You have just recorded, you
ignore
have
us.
just submitted that the termination clause you've referred to.
My lord, he insists to make a false statement to the court. I never practice in such time. Never adopted.
Affidavit in opposition submitted on behalf of the first respondent is taken on record. Paragraph per learned counsels for the parties. Paragraph. The order passed by the registrar within bracket acting, comma, Vishwa Bharati on 22nd July 2022, the order,
Yes, sir.
22nd July 2022, in compliance with an order passed by a coordinate bench of this court on 9th
9th
March 2021 in WPA 2528 of 2021 is assailed in the writ petition. Paragraph. The order impugned is challenged by learned counsel for the petitioner on the ground that grant of mutation in respect of the property in question does not tantamount to grant of title in respect thereof. And since the petitioner's husband was was granted leasehold right in respect of the property on consent of the other legal heirs of the original lessee, comma, further consent of the said legal heirs for mutating the name of the petitioner is not required. Stop. Also, comma, since the erstwhile lessee, Priyobroto Ghosh, bequeathed the property in favor of the petitioner by virtue of a will which was probated, comma, the authority ought to have mutated the name of the petitioner in respect of the property on the strength of the probate issued in her favor. That is your submission. Paragraph. Per contra, comma, learned counsel for the respondents submits that the bequest has been made by the erstwhile lessee in violation of clause 10 of the deed of lease, which talks about consent in writing of the lessor prior to the property being assigned, comma, transferred, comma, let, LET, or mortgaged. Learned counsel further submits that the university is authorized to terminate the lease for violation of the clauses mentioned therein by the petitioner slash the erstwhile petitioner or the erstwhile lessee. Petitioner by the erstwhile lessee. Stop. Learned counsels for the parties seek to take further instruction in this matter. Paragraph. Let the matter appear under the same heading on. When will you come back? 4th October.
4th October. Lordship, after 2 weeks, we can come back here, Lordship. It's only, Lordship has heard the
No,
matter
Lord, 2 weeks
substantial.
It's not possible, no, Lord. There is some internal problem is going on in between inside the university. So it's short time. We are not.
Lordship, can it be at 3:30, your Lordship, if your Lordship pleases? 90 years old lady, your Lordship.
It will be taken. No matter. Next.
276. Lord, I am.
For the National Highway Authority. Lord, the three matters are appearing together.
Yes.
Lord, the first item and second item are the same. Lord, both can be disposed of by single order, but the middle matter, second matter is concerned, Lord, it has some special features. So, Lord, so far as the first and third matter is concerned, Lord, the matter should be, according to me, Lord, I should be candid before your Lordship, it should be referred in view of the section 3H4. Because the impugn order, Lord, the impugn order has been passed against my client, whereby my claim to a disbursement of the award was rejected by the order impugned. The land was acquired for expansion of the national highway. And I was one of the riot and the plot holder, owner of the land. My application was rejected. And thereafter, Lord, this petition has been filed, challenging the rejection out.
The state,
Lord, on the previous occasion also, Lord, they didn't appear, Lord.
they didn't appear.
Although the direction was given for the filing the Lord, the opposition, but the opposition has not been filed.
Who was initially appearing for the state?
They appeared, Lord, they
Who
appeared.
was appearing? Oh, Mr. Sengupta and Mr. Buchai, they are not in the panel now. Isn't it? Mr. Sengupta and Mr. Buchai, they are no longer in the panel. You have to serve a fresh notice.
Lord, may I speak, Lord, in view of the submission that can be disposed of, Lord.
In absence of the state.
Lord, matter will be
Yes.
referred to the,
Whatever the matter be, there has been a change of panel. The present advocates are no longer there in the panel. So law demands that you have to serve afresh. Yes? None appears for the state respondents. Paragraph, since there has been a change of learned counsels in the state panel, the petitioners are directed to serve the office of the learned government pleader afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 27th September.
Lord, 27.
Can be disposed of. It's a short matter. Short minute matter. Huh? Who's continuing? We cannot complete matters.
Only one thing, my lord. Item number 280 and 281. Lord, item number
321.
280 and 281.
Yes.
The 28 matter, item number 281 is already covered up by your same judgment passed by your lordship. So if your lordship kindly fix it up on next Monday.
I am not calling them. Let them appear. It will appear. I'll take up.
Next matter is mine.
If you are used taking it up.
But the difficulty is, I tell your lordship, my lord, the matter is appearing before my lord, at least more than a year. And my lord, at least 5 times, since my lord, sometimes one of the respondent is not appearing, the matter is repeatedly adjourned. I have my lord, a copy of at least 5 affidavit of service intimating them that the matter will appear on particular date. My lord, my only prayer, because my lord, there is 1,000 of potteries remain closed due to the non-supply of unused coal. It's not a matter of 1 or 2 person. What I am praying, my lord, kindly fix the matter next Wednesday at 3:30, my lord, so that I can serve again.
That will not be possible because I have several 3:30 matters fixed already before the vacation. 3:30 will not be possible. Come, I'll consider.
Then, my lord, let the matter
Please
remain.
for the respondents in this matter, anyone?
Today none appears. My lord, let the matter remain its position, my lord.
It will. থাকে যেন, ওপরের দিকে। This is 279.
279, my lord.